Courtmaster, can you hear me? Courtmaster? Hello, Courtmaster?
Yes, sir.
Yeah, I'm S. Ganesh, Senior Advocate. I want to mention item 95. I think it is on list, page number 14 of the list. I'll wait till you call it out, but I just wanted to tell you. Item 95.
Yes, sir.
All right. Boring
Yes,
Institute. It is on page 14.
Page 14.
Thank you very much. Thank you. I'll
Yes,
wait
sir.
for you to call it out. I'll wait for you to.
Yes, sir. Yes.
Thank you very much. I've given notice to the others.
Okay.
Thank you. Thank you.
ನೆನ್ನೆ ಮಾತಾಡ್ದವಲ್ಲ ನನ್ನ ಮಗನೇ ಬರ್ಬೇಕು ಮೇಡಮ್. Page number 1, serial number 1 to 5. Page number 2, serial number 6 to 14. Page number 3, serial number 15 to 22. Page number 4, 23 to 30. Page number 5, 31 to 37. Page number 6, 38 to 43. Page number 7, 44 to 49. Page number 8, 50 to 56. Page number 9, 57 to 63.
Lordship may have it after 2 weeks.
List after 2 weeks.
Interim order.
At
may take.
request, interim order, earlier grant is extended till the next date. Office objections to be complied with in the interregnum.
Page number 10, 64 to 68. Page number 11, 69 to 75. Page number 12, 76 to 82. Page number 13, 83 to 90. Page number 14, 91 to 97.
May I seek your lordship's indulgence for a minute, lords? I appear in item 95.
Yes,
I'm on my legs in a part-heard matter in the first half of the morning. Could this matter be taken up at 2:30? I'll be very grateful. I've already informed the other side.
it may not reach
I'm
today.
mentioning the matter.
It may not reach today.
It may not reach today at all. Can I take my chances at 2:30? Would you hear it
There
at
are-
2:30? Because
There are other matters. We can't jump the queue.
no, I'm sorry, but there is a prayer for some urgent interim direction. I'll be very grateful.
No, we have already granted interim prayer. In a
In a
connected
connected
matter.
matter, in a connected
No, that
matter.
is in
On
other
par
connect. Yeah, but
Follow
this
orders
matter stands on a
exactly.
somewhat
What we
different
received-
footing.
We've
This
received
matter
demand
stands on
notices yesterday, so we have to pay up the amount in 7 days. We received it yesterday.
Let us see.
Yes.
Let us see. I'll accommodate. Let us see.
I'm grateful.
At 2:30, I'll be very grateful if my lords can take it up.
Let
I'll
us
be
see. Let us
subject
see.
to my lord's convenience.
Yes, let us
Number
see.
15, 98 to 103.
My lord, serial number 103. One of these matters had come up on Monday, if your lordship remembers, and the only prayer being sought now is a direction to the Commissioner of Income Tax Appeals to dispose of the appeal quickly. There is some urgency. If your lordship is able to take it up today, no problem. Otherwise, can it be listed in the fresh matters list on Tuesday, my lord?
Only for direction for disposal, is it?
Please, my lord.
Who's
The connected matter 103.1 is in fact still fresh. It's coming up for the first time today.
List in fresh matters list.
Lordship, I will take notice, it's, they
Right.
have served the copy. minute.
103.1.
Yes,
And Council Sanmati accepts notice for the respondent. List the matter in the fresh matters list on
16th.
16.
Oblate.
Page number 16, 104 and 105.
Your Honor, serial number 85.
Just wait, just wait. Aita,
List two, serial number, page number one and two, page number 2, 3 to 6, page number 3, 7 to 13, page number 4, 40.
ಯಾವ್ದು? Okay, ಅಲ್ಲಿ ಎರಡೂವರೆಗೆ ನೋಡಿ. ಅದು notice board ಮೇಲೆ.
Your
Yes,
Honor,
this-
serial number 85.
Yes,
It can be adjourned to next week, Your Honor.
85. At request, behalf of the petitioner, release the matter next week.
Interim order can be extended, Your Honor.
Interim order earlier granted is extended. Yes.
List 1, fresh matter serial number 1, Malina, N.K. Ramesh.
Yes, sir. Lordship had directed me to produce affidavit.
Let him come as soon as Mr. Ramesh comes, I'll take it up.
Aye.
Serial number 2,
Your Lordship, kindly pass over. Madam has gone to the other court.
Pass over.
serial number 3,
My lord, I appear for respond, my lord. Your Lordship may pass it over. Welcome. Covered by your Lordship's order, my lord. It may be passed over immediately after orders list, my lord, your Lordship.
Immediately after,
Orders list, your Lordship may kindly take it. I'll just take the judgment to pass by your Lordship.
pass over.
I'm grateful.
page number 4, serial number 4, Madhusudan.
Dispose of it, not ಮಾಡಿಟ್ಟು. Yes,
My lord, may I please your Lordship.
ಜಾಸ್ತಿ ಇದ್ದಾರೆ ಮಾತ್ರ.
This is a writ petition filed against order under section 264, which is at page 32, my lord.
ಯಾವ್ದು ಹೇಳಿ?
The assessee is an individual. He sold a property and he reinvested in another property. He also deposits some amount in the capital gains account. All these were accepted in the first round of assessment by a 143(3) order, which is at page 129, my lord.
120.
129, first round assessment accepted. The case was reopened and an order under 143(3) was passed, which is at annexure B, page 39. Against this order, we filed a revision petition, which your Lordship will get at page 131, my lord, the revision petition. And that is annexure J. And the order on the revision petition is impugned before Lordship at annexure A at page 32. The facts are very simple, my lord. The assessee sold a property on 14/2/2014 and bought a property immediately, but the completion of the said property had taken 3 months beyond the 3-year period. So in view of that, they are reopened it and they have taxed it totally. I have 3 submissions to make, my lord. First is there is a division bench judgment of our court where if it's a reasonable small amount, they should have. What have you said? Lordship may take to para 8 of the judgment, which says that the money has already been paid to the investor way back in 2000. It's not the money is not spent. The money is already spent. The builder has already completed the building. Apartment is ready. It got completed about 2-3 months later than it. The scheduled date, my 13/2/2017. It got completed on 1/6/2017, where we have been handed over the possession of the property. Because of that, they are saying that I am not eligible for exemption in reassessment proceedings. This is my first ground, my lord. In this regard, your Lordship may see para 8 of the judgment I have passed on. I read para 8, my lord. Section 54 of the Act is a beneficial provision which promotes for construction of residential house. Such provision has been construed liberally for achieving the purpose for which it was incorporated in the statute. The intent of the legislature, as could be discerned from the reading of the provision, would clearly indicate that it was to encourage investment in the acquisition of residential plot and completion of construction of residential house in a plot so acquired. A bare perusal of the said provision does not even remotely suggest that intends to convey that such construction should be completed in all respects in 3 years and made habitable. The essence of the said provision is to ensure that assessee who receive consideration,
Yes, now you have spent the entirety in the,
entire money has been paid to the builder. My lord, your lordship will get it at page 130,
yes,
132, my lord.
My lords, the stand of the department is such that I have to file a statement of objection, because what they say is that at the time of investment itself, he knew that it is going to take beyond 3 years. That is the contention, my lord. Let me examine this judgment and then file a statement of objection.
Yes.
Because it is morally on a factual, if it is a spillover extended. the
Lord Senior
construction
Counsel appearing on behalf of the
Beyond the
petitioner
control of the officer.
contends that the benefit to be extended under section 54F of the Income Tax Act relating to capital gains ought not to be denied as long as the investment of the entire net consideration was within the stipulated period, though completion in all respects was beyond the stipulated scheduled date. Full stop. It is submitted that the scheduled date was 13/2/2017, while the handing over of the property after completion was 1/6/2017. However, it is submitted that the entire net consideration was invested during the stipulated period. Full stop. In support of such interpretation to be placed, reliance is placed on the order of this court in Commissioner of Income Tax, Bangalore versus B.S. Shanta Kumari, 2015, 60 taxman.com, page 74. In light of such contention raised, there would be stay of
Annexure B1 to B4, my lord.
annexure B1 to B4. Respondents are at liberty to seek for modification of the interim prayer upon filing statement of objections. Yes,
5, Chidananda Ras BS.
I'm appearing for the petitioner, Your Honor.
the internet thing ಬಂದ್ಬಿಟ್ಟು. ಇರ್ಲಿ. Yes,
Got, there's a challenge against the adjudication order, Your Lordship. The adjudication order, Your Lordship, is at annexure A.
who appears? Yes. GST Council,
The first three is GST.
Arvind will appear, my lord, GST company.
who appears?
Union and GST Council.
Land
one.
Council,
R1 and R2.
R1 to
R1 and 2.
R1 and 2, Land Council Arvind Chavan accepts notice. Land Council Shamant Naik accepts notice for 3 to 5.
3 to 5.
Who's the answering respondent?
Your Lordship, yes.
ಎಲ್ಲ ಮೇಲ್ ಹಿಂಗಾಯ್ತು, ಎಲ್ಲ ಮೇಲ್ ಆಗ್ತದೆ.
It was dated.
Yes, what is the matter?
Your Lordship, the order is passed, Your Lordship, on 31st December 2023, Your Lordship. It's at annexure A, Your Lordship. The order, Your Lordship, is signed on 31st December, Your Lordship. On 22:55 hours, Your Lordship, it's at the order signature is at page 52, Your Lordship.
68. Commission.
Lordship, the last Madhu Karibasava ARA, this is the digital signature, Your Lordship, but the last line, Your Lordship, dated 31/12/2023, 22:55, 11 hours, Your Lordship. That's the time when the order is passed.
That is 10:55.
Yes, Your Lord. And the GST DRC 07, Your Lordship, is at page 53, annexure A1. That DRC 01 is digitally signed on 10/1/2024, but it is overridden by a signature on 31/12/2023. That's at page 53, Your Lordship.
No, what is the,
Your Lordship, the
Significance-
provision says, Your Lordship, that the order is to be passed within 3 years from the date of the issuance of show cause notice.
3 years from,
the date of issuance of show cause notice under section 73(10) of the CGST Act, your lordship. Wide notification number 9 of 2023, your lordship, it's at Annexure M, page 116, your lordship.
just 1 minute, Manjuna. ಇದು ಹೆಂಗಿದೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡೋದು ಕೊಡ್ತೀವಿ
ಇಟ್ಕೊಂಡು
page
116, your lordship.
116.
6, your lordship. There was a notification extending the time limit till 31st of December 2023 for the financial year 2017-18, your lordship. It's at page 116, Annexure M, your lordship.
Madam, total number for mail
31st of December
31st of December 2023, your lord.
for 17-18.
Yes, your lord.
Ah.
Lordship, my argument, your lordship, is that section 73(10), your lordship, state that the proper officer shall issue the order under subsection 9 within 3 years from the due date for furnishing of annual returns for the financial year to which the tax not paid or short paid or input credit wrongly availed or utilized relates to, or within 3 years from the date of erroneous refund. Your lordship, this date was extended till 31st December 2023, your lordship. The order got to be passed on 31st December, but it was not issued to the assessor. And your lordship, under rule 142 of the CGST rules, DSC 07 should also be issued immediately on passing the order, because that's also a mandatory requirement under rule 142, your lord. DRC 07 get issued on 10/1/2024, which is beyond the jurisdiction, your lordship, of passing the order by the adjudicating authority.
Rule
142, your lordship, of the CGST rules, your lordship. 142 subclause 5, your lordship. Shall I read, your lordship? A summary of the order.
No, this is, so this, now the order under section 73.
Yes, your lordship.
So this summary is mandatory.
It's mandatory, your lordship, because that is the order which creates the tax liability on the SSC, which is uploaded.
What is the legal position? Any judgment on the point?
Your lordship, there are two decisions of the Kerala High Court which I have not carried.
Yes, what do you say?
Your lordship,
There's been an extension under 168A.
Correct. So what he's saying is, no doubt there's an extension.
Yes.
But the order must be issued. And if no summary is issued, then summary is issued
Verify, my
under
lord, it
Rule
usually is uploaded
142.
along with the main order. Let me verify with the officers, my lord, I have it next Tuesday.
So he's saying it's at 11, it's at 10:30. It could not have been uploaded.
Yes, your lordship, it's beyond the office hours.
No, but the summary is admittedly issued next day.
On 10th, your lordship.
So admittedly.
Yes, your lordship. I have taken the screen page, which is at page 123, your lordship. The orders, nothing is available on the screen page, your lordship. It's at page 123, your lordship.
Okay, let us see. We'll consider it. Actually, you find out. Yes, what is the date? Now, it's not in dispute that the order is passed only on 31/12/2023 at 10:35.
Yes, sir.
Yes, your lordship.
And uploading of the summary of the order is on 9/1.
10/1, your lordship.
10/1/24.
2024, your lordship.
So whether this is not a summary can be ignored, whether it was actually uploaded before 12 AM, you have to see.
Lordship,
Very
care.
So long as there's service, my lord, I don't see the
No, it correct,
challenge.
but it should be issued, is what he's saying.
Section one
Lordship, may I have
69.
this on Friday, my lord? I'll seek instructions and make my submission.
Otherwise, I'll have it on Tuesday.
Great.
Relist the matter in the orders list on next Tuesday.
Obliged.
Orders list.
No precipitated action till then.
Or
the
not
orders
to take
passed.
precipitative steps till the next date. Let us.
Serial number 1, Malinath, NK Ramesh.
In this case,
I'm sorry, my lord. After the first court, my lord,
directed me to file the affidavit along with the pass card.
The previous case.
Yeah, yeah.
Have you served on the college?
Yeah.
College.
A college, in fact, I had served him, in fact, and not served. In fact, I had brought it as a notice of the core, college yesterday, that this is a difficulty which you are facing, whether the applied sciences and applied mathematics, they.
No, but they have to appear, isn't it?
But in the meanwhile, I just got a memo, I can file it, in fact. It is a pretty side.
No, but you should ask them to come before the.
I'll keep in present. Yes, sorry.
Which paragraph affidavit?
Sorry?
Affidavit, which paragraph?
The paragraph at 3.
Yes.
Hence, in compliance with the directions of this, that mask out of these 3, and the mask cards of the 3-year diploma course that the petitioners have completed from the respondent number 5 institutions are attached here to this affidavit, so, which clearly indicates that all the petitioners to the petition have studied and passed the exams in subjects applied sciences. The marks as provided in the mark sheet are inclusive of applied science practical as provided in the notification 29/10/2022, that is Annex F. The marks card of the first and second semesters indicate the completion of the subjects Mathematics 1 and Mathematics 2. That is, applied mathematics falls under the ambit of these 2 subjects as required by the same notification which is taught by the 2 semesters.
Now, what are the subjects? Those.
These are only 2 subjects.
Subjects
the-
are applied
the-
science and applied mathematics.
Mathematics.
Yes.
Applied science, my lord, to some extent, that nomenclature is there. As far as mathematics is concerned, there is no applied mathematics in the studied mathematics. If we have to go into it, my lord, then we may have to compare the syllabus, all that, my lord, will happen.
What is this memo of additional documents?
This is which is been issued by
Where is it, sir?
the college itself, which says the following applied science at page number 3, Annex J.
That copy.
This practicals.
Sorry?
Practicals.
Practicals. Mathematics includes applied mathematics, in fact. It is not just a subject by itself, it includes applied mathematics.
That is their version, my lord. That is their
Correct.
version.
That's a matter to be tested
Yes,
eventually.
that. Either DT or AACT, they have to, my lord, give that equivalence. Comparing the, my lord, the syllabus of them and, my lord, the other syllabus. Approved syllabus.
And moreover,
Please let the government also look into it. Let the government also look into it. And if required, the government can ask the concerned to give that equivalence, or they can set up a committee.
And give an equivalent certificate so that not we blindly take it. As far as we are concerned, not if the equivalent certificate is there, unlike in CBSE from other states, we insist on an equivalent certificate. Once it is.
But now what do we do?
That's the.
but then the
that only
counseling
takes
ends
the time,
tomorrow.
that is what.
I'm sorry.
Huh?
They're running against the time, that is it.
Tomorrow is the last day at 11 o'clock.
No, no,
And-
correct, but just imagine, look at it differently. Suppose they don't give finally equivalence.
That's it.
That.
Then there, so instead of that, why don't you wait for 1 year? We'll get it completely solved. We'll get it solved. You may lose 1 year, but you may get final relief.
That's the best solution. That's the best solution.
Instead
but
of,
then- but then-
the reason I'm saying is, now suppose we were to give interim order, they're selected, then they get married, they get some
in
job.
fact-
No, just wait. I'm telling you what we have seen. Then they'll come with their children
Yes, yes.
only on the lighter vein. And then say, now after 3 years, 4 years.
You have to go.
No, I'll not plead guilty, equity at all. I'll not
No,
plead.
it's
that
easy
is
to
easy.
say that.
That's my undertaking.
No, it's easy to say, but just look at it like that. But after 3, 4 years after working, if you have to go back, then it becomes completely unreasonable.
No, in fact, what has happened is in this case, the petition number 1, in fact, his results were declared, then the database was removed and he held a 21st rank in the.
No, correct, but it's on this ground. Either you are qualified or not
Not
qualified.
qualified, that's
There's
it.
nothing in between.
But then
Hmm.
they may be permitted to, because you know,
So what
otherwise-
is the whole purpose now? Tomorrow, if I won't be, I may not hear this matters. It may come up under somebody else. And that, and then they take a strict view. You are worse off than what you
No,
are.
I'll have to face the situation. I'll have to definitely face the situation. No doubt about it. That's the reason as to why I'm ready and willing to give an undertaking that I stand by that I'll not plead equity at all. But right now, because the time is so short. in fact-
Correct. Time is short for what now? 1 year you lose, that's all. But if it's found that you are ineligible, you lose the whole, you are not, if you are not entitled, you'll never be entitled. That they have to realize.
But one thing, losing a 1 year is a very, very
No,
harsh.
that's 1 year is nothing compared to the final relief you are
Sir,
asking.
I plead, because this is sort of a mercy petition in
No
fact.
mercy, no mercy.
But-
You're either qualified or not qualified, nothing in between.
But anyhow, I have given the equivalence because I have also given the mass card also, which shows, yes.
Yes, Ramesh, what shall we do?
My lords may pass over this matter. What I'll do is I'll secure instructions from the department on whether the applied maths syllabus would, the second document submitted by them, my lords. If
Correct.
that is so,
But
in-
what you will have to finally do is, you will have to examine it.
yes, my
And
lords.
then see whether the mathematics done by them and their syllabus would be equivalent to
Yes, my lords.
applied maths which are stipulated in that.
Yes,
For
my,
that, one exercise will have to be done, which cannot be done right now.
yes, my lords, yes.
So if we were to consider prima facie, make an observation and get affidavits filed. And then, but you must take this up at the earliest
Yes, my,
and have a committee, have the equivalence also and place before the court looking into the syllabus of mathematics and applied mathematics.
yes. As in the meantime, the institute, as your lordship said, would also have to be put to terms because it's been a long time and they have to
No, we'll
secure
call them. We'll call
that.
them.
If that is done, my lords, we'll have absolutely no.
Correct, we'll fix a date.
Uh.
But you will have to take a decision because you have mentioned it.
Yes, my lords, I'll
Okay.
secure instructions, my lords, on that.
So let them file their affidavit, but immediately you do it. Don't wait till
Yes, my lords. As
There
your
is,
lordship's order.
you call your clients, call them, whoever is there.
He's the petitioner, first petitioner.
Yes.
Where are others?
Petitioners, college calls.
No.
Yeah,
Petitioners are present.
correct. Now, in case we give an interim order,
Yes.
you can understand, isn't it, English?
Can I understand?
Or Kannada you want to speak, whatever you
ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ಬೇಕಾ ನಿಮ್ಗೆ? English ಅಲ್ಲಿ.
So in case we give an interim order permitting you to enter to go through counseling, that would be subject to government determining whether applied mathematics and applied science, which they have stated has been done by you. If the government, after setting up whatever, comes to a conclusion that mathematics is not the same as applied mathematics, because we don't have the benefit of the syllabus of mathematics of your course, then whether you are employed pursuant to now whether you are done 1, 2nd, 3rd, 4th, 5th year, you will have to come back to ground zero. That is your choice. Or you wait for some time. Obviously, you are going to skip this this year. By next year, something will be decided. It's you must take an informed decision that you communicate to your.
Cyber ಹೇಳ್ತಾರದು applied mathematics,
DT
mathematics.
can do a lot for all these students. One examination of applied science and applied mathematics with their this thing, if they do it, one examination for the next year, so that they can apply for the next year.
Next year.
If they have that
certificate. That will be too harsh, in fact, because they instruct me, one thing is, let us be given a chance. We'll not plead. Of course, as the Lordship has rightly observed, if the government comes to the conclusion that applied mathematics and mathematics are not one and the same, then well, they had to lose. They have not gained anything either, even right now. But let them be given a chance. Because what has happened is, they are the sin more than the sinners, in fact. Someone else commits sins and they are, so let them be given a chance. I made them understand, yes. If supposing something happens, they are ready to face that situation also. Not that we are going to play it, okay, our wards are already into third year or 4th year. But that's not going to be a plea then.
So that will be harsh.
They are saying, just give us a last chance.
It will be very hard.
Yeah, that will be very harsh. Instead of losing 1 year and do the applied science and some examination. If they
Correct. Absolutely.
Yes.
I am with
But
you.
1 year will be because they'll be losing a year. So even otherwise also, that if they are not entitled, they'll not be entitled throughout. That's a different thing.
And they'll be getting it for second year. Second year.
They'll
be working, they'll be studying there. And suddenly if the government says you have to come back at ground zero, at least
No,
now.
but I have verified, in fact, that there is the instruction of applied mathematics includes applied mathematics also.
Huh?
It is there.
Let us then, but now the onus is upon you to, at the earliest, to sort it out
Yes, my lord.
by making an analysis of the subject and what you have mentioned.
It includes the applied mathematics also, the concept. Applied mathematics means how the mathematics should be applied to the.
Anyhow, I can't understand.
Even I am also at a loss. What do you want to say?
Yes, what do you say? I'll pass a judicial order,
Yes, my
but it's at, they'll have to file affidavits,
Yes,
not
my lord.
claiming equity, and it's their headache. But you will have to react proactively. That's all.
Yes, my lords, we'll.
And the Lordship put the DT on terms that exercise has to be done as early as
Yes, yes.
possible, so that
Yes, yes.
they will not lose out on time. Yes.
Within 3 months.
Yes.
In 3 months, my lords.
Yeah. It is like winning the T20 World Cup and later they say that you have stepped over the rope and they say give it back. It's better it was decided then.
Exactly.
That's exactly.
The petitioners.
But if a Lordship can permit me.
Yes. Petitioners have sought for. Written the nature of mandamus to direct respondent 1 and 3 to update marks of the petitioner students in the relevant database. And further to declare results of the petitioners for the exam held in DCET 2024. Full stop. It is the case of the petitioners that their results were withheld on the basis that the course undergone by the petitioners at NTTF was not recognized by
AICTE.
AICTE.
That's the fourth respondent.
Full stop. However, they rely upon notification at annexure
FF. Dated at 29/10/2022.
at annexure F.
159.
Dated 29/10/2022. whereby professional education institutions within bracket amendment rules 2022 had recognized diploma in NTTF within bracket tool and die making close bracket, as well as diploma NTTF close brackets with electronics, and submits that in light of the petitioners having written the exams in the above two subjects.
No, no, some of them, tool dyeing,
Some of them are electronics.
some of them is the tool and die making, and some of them are electronics.
Are entitled to get benefit of the amendment rules. Full stop. However, it is noticed that there is a note appended to the notification at annexure F, which stipulates that candidates of NTTF within bracket Karnataka centers only close bracket diploma will have to study and pass applied science and applied mathematics. Full stop. It is their further contention that in terms of the documents produced, they have passed the applied science and have also passed the mathematics subject, which is equivalent to applied mathematics. Full stop. Taking note of the said contention and also affidavit filed such of the petitioners, if have cleared applied science and mathematics, are entitled to benefit of interim order of announcing the results for DCET 24.
23, 24. 2024. 2024.
Now the marks is to be announced for which?
24.
DCET. DCET 2024.
And also the KEA, because the KEA is the examination conducting authority. They have to declare the results. Third respondent.
Such a declaration of results to be made by respondent number 3. Full stop. It is made clear that KEA to verify from the material placed before this court as to whether each of the petitioners have passed applied science and mathematics. Full stop. Prima facie, the question as to whether mathematics is equivalent to applied mathematics is a matter for adjudication during the course of the proceedings. Full stop. Subject to the above, the respondent number 3 to announce the results and the other respondents to take appropriate steps to enable the petitioners to take part in the ongoing counseling. Full stop. The petitioners to file affidavits within 3 days from today.
Yes.
That they will not claim equities in the event the court were to pass orders contrary to the interim relief now afforded. Next. However, taking note that there are large number of students who pass out from the said 5th respondent institution, the government to immediately take steps to determine as to whether applied science as referred to the notification at annexure F has been undergone in the course of the fifth respondent institution, as is evidenced from the mark sheet issued by the fifth respondent. Insofar as mathematics also stated to have been completed by the petitioners in the fifth respondent institution, whether the said course would be equivalent or would be the same as applied mathematics as referred to it in the note at annexure F is a matter to be determined by the government, which has passed the notification at annexure F. While doing so, the government is at liberty to take necessary inputs from the concerned if it is so required, as the government is the author of the notification at annexure F. Such a process to be completed within 3 months from today. Taking note that many of the students who pass out from the said institution would be claiming similar relief. It's made clear that the order passed cannot be construed as laying down a position of law entitling automatic extension of the interim relief granted to other students of the college, which will have to be evaluated independently. This is only being, the interim order is passed only in the peculiar facts of the present case.
In fact, actually, sorry, I'm sorry. A direction may be issued and apply for, appear for the counseling also tomorrow by within.
Yes, we have stated that.
And by hand order.
Yes, yes.
Memo is.
Serial number 6, Niruddhar Naik, 6.
Lord, in this case, challenge is to annexure C, which is an order, an order in original confirming a demand of tax on me, on the petitioner. My lords, I admit that there is a liability, but only the fact that there are certain payments which I have made which have not been taken cognizance of. And therefore, my lords had asked us to file a chart, which was also filed. So if the matter can go back to the adjudicating authority, let them verify.
What
Lord,
is the
this entire
reconciliation?
Reconciliation, you know, my lords, if my lord see page number 3 thereof, at the fag and bottom right-hand side.
Page number
3 of the chart. The last line thereof. What is payable according to us? This. Yes, my lords, that's the chart.
Page?
The last page, the third page. And the last line thereof.
Yes.
If my lord see what according to us payable is 4423. Whereas the demand, if my lord see in the order, is almost double that, 90.
Now this
92 lakhs 36,000 is the demand.
Okay, what is this reconciliation between?
Between GSTR 1 and 3B.
What is 1 and what is 3B?
1, my lords, is the whatever comes into my
1 is what is declared
yes.
by him.
And 3B is
two
after the adjustments of credits and payments, we file 3B.
3B is a verification done by the authority.
By the authority.
By the authority.
So
the difference is mentioned under 2.
So declared in what ITC?
Yes. Declaration is done under 1.
That is of the ITC that
yes.
he is claiming.
Not ITC, the returns. The returns that is filed. He files certain returns, he declares it under 1. Under 2 is the difference amount. Once I verified with the portal, 3B is what I have received as the department.
GSTR 1 is the outward supply record, my lord.
Outward supply.
GSTR 1, my lord, is an outward supply, return for outward supply by a supplier to be filed by the 10th of the succeeding month. If I made 100 supplies, all those 100 supplies have to be shown in the GSTR 1 return which I have to file by the 10th of the next month. Based on the GSTR1, the recipients, all the 100 recipients, this credit which is available to them will get populated in their GSTR2 or 2A, 2B that they have now. One is static, one is on real-time basis. So GSTR1 is my outward supply. GSTR2 is the inward supply of the recipient. GSTR3B is the monthly return which is to be filed by the 20th of the month of the subsequent month. So GSTR1 is a return for outward supply. 2 is for the inward supply by the recipient. 3B is the return to be filed by the supplier of the goods or services. So normally the whatever is the GSTR1 file, that and we get auto-populated to the GSTR3B on a monthly basis to show the outward liability.
On the basis of 2 also.
2 is one of the recipient will know what is the credit available to him. But once now everything is online. So if I file the GSTR1 by 10th of the month, all my supplies made with the GSTN numbers of the recipients, it will get populated in their GSTR 2A or 2B. That will be the credit input tax credit which is available to those assessees, recipient assessees. So if that reflection is not done, that is I don't file my GSTR1 properly, the GSTR 2A will not get populated. Therefore, they will not be eligible for credit. That's the scheme. And 3B is the monthly return.
So now this
In the facts of
reconciliation between GSTR 1 and 3B,
There is a difference.
There is a difference.
so that you will be relooked into by the authority.
Lord, he has not even raised this ground in the writ petition. This is actually a mercy petition, if I were to humbly submit, is that all he has said is that he wants to go before the assistant commissioner. He wants to pay the tax. He doesn't dispute the amount. He wants section 80. There's a provision where he can pay it in installment of 24 months. This is all that he's asked for. Now he comes up, my lord, and says that no, there has been an issue with the reconciliation of the accounts. If your lordship sees the entire petition, not a single ground is raised relating to this. All he says is his prayer is section 80, let me pay up in installments. Now, recently, my lord, he comes and says, no, there is a mismatch. If there is a mismatch, your lordship may have it on Tuesday. I will speak to the officer, my lord, and make my submission.
My lords, they were supposed to do this on the last occasion.
Let us see.
No, my lords, my only submission is this. In the facts of my case, what has happened?
Let us see. He wants to complete his instructions.
Yes.
No, my lords, I'm not disputing any of this, my lords. Whatever my friend says is correct. I mean, I'm not disputing that. The only thing is that I had a security services company, which is this. But pre-COVID, there was an opportunity for me to start off a transportation company with BIAL. I did that. COVID struck. I ended up buying about 80 to 100 high-end cars. And after COVID, that almost completely finished me because I had to make the prepayment, EMIs and all of that. I couldn't concentrate on this. In the meanwhile, no, these are all facts. There is an FIR also which I have enclosed to these.
Fine. You may get relief next week. Just wait. Let us. He only wants to verify and get installed.
I'll verify.
That is what they said they will do on the last occasion.
No, that's okay. Never press your accelerator.
Great.
Yes. And release the matter on
Tuesday.
Tuesday. Yes. Same stage.
Great.
Yes. Next.
Please, your lordship. There's an income tax matter arising out of ex-parte orders. The SSE has not received the mail. He's a salaried employee. There is one transaction of capital gains in the year 15-16. He has filed his return only in respect of salary, but in that year he has not filed the return. It is selected for scrutiny. The email ID belonged to the tax practitioner. Only in the penalty proceedings they have physically verified, and he has come to know about it. Thereafter, we have filed this petition. I'm only praying that go back to 148 AB stage. There is a technical issue on assessment here, but the assessing officer did not have the benefit of the sale deed and the purchase deed. I undertake to, if it can be remitted back to 148 AB.
No, then how has he calculated capital gains?
He's added the whole amount. 78 lakh sale consideration been added as income, saying it is short-term capital gain. He does not know the cost of acquisition, and he's taxed the whole income. I have in fact put a working in the petition, but
where is the order? Capital gains. Let's have a look at it.
Your Honor's assessment order is at Annexure A3, page 49. If Your Honor's were to see page 50, they have reproduced a chart. And 54 is the finding, 4.6.5. 148 lakhs. Along with my salary, and salary TDS is not given. Mercy petition to go back to 148 AB stage. I will file my reply, I'll file the sale deed copies also. Subject to my 149 1B claim also, because the income is less than 50 lakh.
Yes.
The email sent is to the registered email ID.
But it belongs to the tax practitioner and.
Correct, but that apart, he could not have taken the entirety of the sale consideration for capital gains.
Without any assistance, he has done.
On that ground, we'll send it back.
Please, sir.
Send it back to which stage?
148 AB around.
ED or assessment stage is better. Anyway, he has got good grounds for convincing him.
Go back to the assessment and explain.
I'll just clarify now. If I were to go back to 148 AB stage, my capital gains is about 40 lakhs, which has been invested. The entire proceedings could be saved. He need not even take sanction of the PCCIT and pass an order. That is my humble prayer.
No, but you have not participated at all.
Precisely. That is why I'm making a prayer saying thing. In fact, there's a technical issue on the assessment year aspect, but I don't want to press it now. I will file the details. They have reassessed me in the wrong year. I'll just point that out also. If you honest way to take to annexure C, page 85. Heading of the page, Your Honors.
Yes.
This memorandum of absolute sale deed is made and executed on this 20th day of July 2015
Yes.
in Bangalore. This would relate to financial year 15-16, assessment year 16-17. If you honest way to see to annexure A, page 43, the assessment year is 15-16. They have opened 1 year prior. They had to open 16-17. No, I'm not even making this contention. I'm saying.
Correct. We'll notice that.
Please, Your Honor.
That also informs the court to give you appropriate relief.
Please, Your Honor.
The petitioner. But how can you make such mistakes? The petitioner has called in question the validity of the notice under 148 capital A small b at annexure A, the order under 148 capital A small d at A1, notice under 148 at A2, and the assessment and the consequential proceedings, including the penalty order at A6 and A7. In the case of the petitioner, that he did not participate in the proceedings. Reason is email.
Because the email ID belonged to the tax practitioner because he files a return once a year and it's a salary return. He was not checking his portal. He was unaware.
Proceedings as his accountant failed to inform regarding the proceedings initiated by the department. Perhaps because the petitioner was only had income only from salary. Further submitted that the reassessment is sought to be made on capital gains. And for the year 15-16, for the assessment year 15-16, though the sale deed itself is 20th of July 2015 and hence would relate to a transaction to be taken note of in the assessment year 16-17.
Please.
Further submitted that the entirety of the sale consideration is taken as capital gains, as is evidenced from the assessment order, without taking note of cost of acquisition and indexed cost of
Index cost of acquisition.
Indexed cost of
Acquisition,
acquisition.
please.
And accordingly, it is submitted that an opportunity may be granted to make out reply to the 148A B notice. Then Counsel Shri Tirumalesh submits that the petitioner ought to have cannot take the contention that his accountant has not informed that notices were issued by the income tax authority. Next. It is the contention of counsel for the petitioner is to be noticed. The notice and the assessment proceedings are for the year 2015, assessment year 2015-16. Admittedly, the sale deed itself is for the year is on 20th July 2015. Prima facie, the sale transaction would relate to the assessment year 2016-17. Next, it's also noticed in the assessment order that the entirety of the sale consideration is taken without taking note of the indexed cost of acquisition. In light of the above, clearly, matter requires a reconsideration at the stage of 148D order. Full stop. Accordingly, the petitioner is relegated to the stage of making out a reply to 148 capital A small b. All other contentions are kept open. Full stop. The orders at
A1 to A7.
The orders and notices at A1 to A7
Yes.
are set aside. All contentions are kept open.
Let them appear on a given date. Because
Petitioner to appear before the respondent number
1.
1
3 zeros.
on 22nd to make out his reply.
August years. 22/8. 22/8.
22/8. Yes.
Obliged.
Here for the petitioner. The next year A1 at page 58 is assessment order passed in faceless mode under section 144B. My limited grievance in this, my lord, is
Regular assessment.
it is a reopening assessment. I've challenged the reopening as well in this, but at this stage, my lord, my limited prayer is that it can go back for the reason that I have been denied the personal hearing in this matter. This is a matter.
73.5.
My lord.
73.5.
No, my lord,
No,
it is
income
income
tax.
tax. It is income tax matter.
Yes.
So the show cause notice was issued. I had made the reply. I had made a request for the personal hearing in accordance with the 144B, and it was in fact granted to me also initially. On that day, the council couldn't appear, for which an adjournment was sought, requesting rescheduling for the next day, my lord.
You point out.
Yes, my lord. At page 77, my lord.
144B.
144B.
Yes.
At page 1.99999.
Yes.
Small Roman 7, my lord, in subsection 6, it is small Roman 7.
Yes.
In a case where a variation is proposed in the income or loss determination proposal or draft order, and an opportunity is provided to the assessee by serving a notice calling upon him to show cause as to why the assessment should not be completed as per the income or loss determination proposal, the assessee or his authorized representative, as the case may be, may request for personal hearing so as to make his oral submissions or present his case before the income tax authority of the relevant unit. Next, over the page, my lord.
Yes,
A,
yes.
where the request for personal hearing has been received, the income tax authority of the relevant unit shall allow such hearing through National Faceless Assessment Center, which shall be conducted exclusively through video conferencing or video telephony, including any use of any telecommunication application software.
Yes, yes.
My lord, in my case, at page 77, In the assessment order itself, my request has been extracted at page 77, my lord. Para 28, in that,
Yes,
my last para of my reply has been extracted in view of the above.
yes.
In that last two lines, my lord. Opportunity of personal hearing through video conference may kindly be provided in the interest of justice. My request.
Yes, then,
And then, in response to this, at page 185, my lord, the notice, or rather the intimation for scheduling personal hearing through video conferencing is provided. At para 2, it says your personal hearing through video conferencing is hereby fixed for 11/3/2024 at 1 p.m.
yes,
The counsel couldn't appear on that day, for which a request was made through the adjournment module, requesting for the next day rescheduling. Then next, at page 187, no such rescheduling was done, for which through the e-proceeding itself, I made one more request on 12/3, the very next day.
this request was made on the same date, is it?
This request, my lord, is on the next day. On the same day, early morning itself, through the adjournment module, it was done. That adjournment module, my lord, is not visible to us at this stage.
No, 11/3 it was fixed.
It was fixed.
So your request for
Yes.
rescheduling was made when?
It was made that day itself.
That date.
That day itself it was made, but not through the e-proceeding module. There is a separate module called adjournment module, my lord. That time I unable to put the screenshot because that is not visible subsequently.
So
But it's a fact, and which I have also brought out here.
in the assessment proceeding, they say you have not availed.
There is no whisper at all in the entire assessment order, my lord.
Yes, what do you say?
Lords, at page 62, your lordships may kindly
Page?
remand the page 62, my lords.
Yes.
Lords, lordships may kindly consider to remand the matter, my lords. Posts notice 142. Lords, let them file a request for personal hearing. Lords will grant an opportunity, my lords.
Post 142 notice.
Please, my lords, dated 28th February 2024. The lordships will get on top, my lords, at page 62.
Yes. The petitioner has challenged the assessment
Last
order
Respondent.
at annexure A1. The notice of demand at A3. The show cause notice for penalty at A4. The 148 capital A small b notice at B1. 148 capital A small b notice at B2. And order under 148 capital A small d at B3. As well as the notice under 148 at B4. In the case of the petitioner, that during the process of the assessment proceedings, now you sought for in the context of your reply to 142.1, isn't it? Video
Yes,
opportunity of hearing was at that stage.
Initially, the show cause notice was issued even before that 142.1. I made a reply to that. Again, when 142.1 was issued again, I made one more request again.
Correct. Now what you have referred to is in the last
one.
Yes. In Badidira. As regards notice under 142.1, the petitioner no doubt had made his response, but had requested for personal hearing, and opportunity of personal hearing was fixed on 11/3/2024. And on such date, due to inability of his counsel to attend and avail of such opportunity, he had made a request for adjournment. Full stop. reliance is placed on the e-proceedings response acknowledgement at annexure L. It's further submitted that process for adjournment was made through the relevant mode as required under the e-proceedings and same not having been considered. No observation is made in the assessment order regarding the said adjournment request made and proceedings have culminated. It's submitted that the petitioner has certain clarifications to make out to the notice under 142(1). And if the matter is relegated to such stage, the petitioner would avail of opportunity of personal hearing and make out clarifications. Taking note of the facts as made out, including the requirement of affording request for personal hearing as per the procedure prescribed under 144(b)(6) Roman
7
Roman 7 and 8. 7 and 8. It must be noticed that admittedly, petitioner was afforded an opportunity of personal hearing, but as on the relevant date, due to inability to attend and avail of such opportunity of personal hearing, a request for adjournment has been made. Same is evidenced by the acknowledgement at annexure L. It would meet the ends of justice by relegating the petitioner to the stage of reply to 142(1) notice, as well as keeping it open for the petitioner to make out a request for personal hearing as per the applicable procedure. Accordingly, the orders and notices at annexures
A1 to A4, my lord.
A1 to
A4.
A4 are set aside. Matters relegated to the stage of post 142 notice. You already made out your reply, isn't it?
Yes, my lord.
Lords, they have left to seek file
Yes,
a
yes.
letter for personally, only then it will
In
be.
light of response already having been made out to the 142(1) notice, petitioner is now to make out request for now affording an opportunity of personal hearing as per applicable procedure. And the authorities may take note of it and proceed with the proceedings and conclude the same in accordance with law. All contentions are kept open.
My lords, respondent number 1 to 3, I appear. My lords, respondent number 4.
4 I had.
Then Council Sri Dilip appears for respondent 1 to 3, Sri Arun Chavan for R.
4.
ಹೊರಗಡೆ ಸ್ವಲ್ಪ ಗಲಾಟೆ ಜಾಸ್ತಿ ಹೊರಗಡೆ ಗಲಾಟೆ. Yes.
I'm appearing the petitioner, your lordship. Your lordship,
Central tax.
your lordship,
Yes.
it is the service tax issue, your lordship.
Service tax.
So the show cause notice, your lordship, service tax.
Just show him the cost.
File. Give it to me.
Yes.
Lordship, the show cause notice, your lordship, is issued on 21/11/2017, your lordship. It's at annexure B, page 34, your lordship.
Yes.
A reply to show cause notice was filed on February 13, 2018, your lordship.
On
February 13, 2018, your lordship. Few months from the date of issuance of show cause notice, the show cause notice reply was filed by me.
Yes.
Lordship, the first personal hearing, your lordship, was granted on 28/1/2021, 3 years after the issuance of show cause notice. Another PH was conducted in the year 2023, your lordship. That is on 2/8/2023, another PH was conducted by another officer.
Another
officer, your lordship, or
personal
the
hearing
commissioner,
personal hearing.
personal hearing. That was conducted in
Yes.
2023, that's 2/8/2023. The officer conducting the hearing did not pass the order. Another officer passes an order on February 2024, your lordship. More than 6 years, 3 months from the date of issuance of show cause notice. Your lordship, section 73, clause 4B, your lordship.
73.
Clause 4B of the Finance Act 1994. I've provided the copy, your lordship.
Yes.
Your lordship, 4B, your lordship. Section, your lordship states that the central excise officer,
Just one section.
73, the clause 4B, your lordship, in the third page. For capital B, your lordship.
Yes.
The central excise officer shall determine the amount of service tax due under subsection 2 within 6 months from the date of notice where it is possible to do so in respect within 1 year from the date of notice where it is possible to do so in respect of cases falling under the proviso to subsection 1 or the proviso to subsection 4A, your lordship. The time limit provided under the statute, your lordship, is to pass order within 1 year from the date of.
Correct, but that's only a directory.
It is directory in nature, your lordship. Now, your lordship, there are a series of decisions passed, including where the Supreme Court has affirmed it, saying that even though the time period provided under 73(4)(b) is 1 year, it cannot be taken that it is discretionary and the order is passed after inordinate delay. Your lordship, I'm relying on case law, your lordship. It's at page Annexure K, page 214, your lordship. In this case, your lordship, the adjudication order was passed after 11 years.
What is the-
Page 214.
11 years.
11 years in the Sri Baba export, your lordship. Where the Supreme Court, your lordship, affirmed this order stating that and also the Bombay High Court says, your lordship, I will come to that decision next. The Supreme Court has affirmed it at page 218, your lordship. There can't be inordinate delay in passing an adjudication order. The adjudicating authority has to explain the delay as to why such inordinate delays occurred, because 6 years is impermissible. My period, my lords, is 2012 to 2017, and I have to keep books for almost 12 years now. I have no officer who is available now. I can't even explain before the officers and give the document which the officer seeks, your lordship.
Yeah, by itself, we can't say it's vitiated, but you'll have to make out an argument. That's it.
Your lordship, at the Delhi High Court, your lordship, at page 230, your lordship, on the same issue, under section 73,
So let
clause
us see.
4B.
No, we'll see, but I'm saying you'll have to demonstrate at the time of, now what is the stage of the process? What has happened now?
Your lordship, the adjudication order is passed, your lordship, and OIO is passed in Annexure J.
Application is ordered
After 6 years, your lordship.
on 27 February 24, my lords.
More than 6 years, 3 months, your lordship.
My lord, whether this could
The
be.
decisions are categorical.
We allege that, my lord, this order is passed without jurisdiction or, my lord, violation of principles of natural justice, so as to
Some prejudice is caused, you have to demonstrate.
demonstrate. Otherwise, my lord, he has to file an appeal under 107.
No, this is a service tax, 1984.
Service tax.
Yes. Lordship, I am on the.
Service tax means you have to go
On
to
the
such
issue, lordship, after 6 years, 4 months, an order is passed. And I have no documents to give. It's almost 12 years. The period is 2012, your lord.
You get
That's what the Delhi High Court
Get
said.
instruction letter.
Please, this is, my lord, service tax matter, my lord, then Sestat, he has to file an appeal before the Sestat.
No. I'm not denying on the appeal. Is the adjudicating authority right in passing an order after 6 years? There are category of decisions. My lord, I'm referring to the Delhi High Court in
Let
page
us-
230.
My lord, he has to
Same
make,
under section 73, subclause 4B, your lord.
my lord, he has to make one party as a party respondent
Yes.
I think, my lord, originally he falls within the jurisdiction of the, my lord, the Commissioner of Central Tax, Bangalore North. However, my lord, I think, my lord, the Commissioner Mysore was holding charge. So he passed an order as an additional charge he was holding, my lord, of this. So the Principal Commissioner, Bangalore North is the, my lord, the proper party.
My lord, the adjudicating authority has stated that by an order, these matters have been passed on. That is no issue because the order officer can pass on the jurisdiction to another officer, which is being done regularly. My only argument, my lord, is that it cannot be so inordinate that it will go
we'll see.
beyond 6 years, 7 years.
That we'll see. Now, is he required to make or it's okay?
My lord,
Is required to make or is it okay? Party.
but he has required to make, he has required to make. He is regularly assessed and was
Petitioner
regularly
is
assessed under
permitted
that.
to add
He is
an
required to make.
additional respondent, namely the
Principal Commissioner, Central Tax, Bangalore North.
Principal Commissioner, Central Tax, Bangalore North. Full stop.
Order
Now,
noted.
Council for the
Annexure J.
petitioner
So-called
submits that
GST.
in terms of section
My lord,
Chidanand, in terms of
Hello, sir.
section completion,
73 is a clause 4B, your lord.
73,
The clause 4B, your lord.
4 capital B.
Capital B.
The
Book photo.
proceedings are to be concluded within
A reasonable time, your lordship, that is within 1 year is what the statute mandate.
within a reasonable time. And in the present case, as the
if possible on third.
reasonable time.
That has been
In the present case, the show cause notice was issued
on the 21/11/2017, your lordship.
21/11/2017, and proceedings were concluded only on 27/4/2024. And accordingly, it's contended that the authority has to make out reasons for such unduly long period taken for completion of adjudication, failing which order could be interfered with as power is exercised beyond a reasonable period of time. In light of the contention raised, subject to further consideration, there would be stay of
Annexure J, your lordship.
Annexure A, and Council G1 accepts notice for the respondents. Yes. Yes.
Wait, please, your lordships. My lords, the present challenge is concerns an order issued for GST demand
Joint Commissioner of Central Tax.
on the ground of intermediary services.
Intermediary service.
My lords, there for the same petitioner, albeit for a different period, there is a interim order existing in its favor. My lords, the issue is that the petitioner is basically a part of
same contention.
Same contention. My
Where is
lords.
that order?
My lords, that order I'll just pass. This is 10, 10, 10.
The counsel for the petitioner submits that in the case of the same petitioner for a different period. This court has considered an identical legal contention in WP 9784/2024 and granted interim order, and on parity, the same interim order and the benefit of the same interim order may be extended in the present case also. Also, the interim order passed in WP 9784/2024 on 25/6/2024 reads as follows. Accordingly, subject to further consideration, there would be interim order of
Annexure C.
Stay of Annexure C and proceedings pursuant thereto. The respondents are at liberty to seek for modification of the interim order upon completion B promote.
My lords, there is a connected item, item 80, for the same petitioner, the same issue, but a different show cause notice for a different period. So my lords.
Same petition.
Same petitioner.
18. Serial number?
80.
Connection.
ವಾರ ರೆಡಿ ಮಾಡಿ ಕಳಿಸ್ತೀನಿ.
Your stay of annexure?
B. C or B?
B. And pursuant and proceedings pursuant thereto, same order. R2. Arvind
R2.
Chavan. Arvind Chavan, they directed to accept notice for the second respond.
R1 Union of India.
Yes. Somebody's already filed Wakala. Yes.
Obliged.
Appear for the petitioner in this case. The writ petition instant filed is challenging an order in original dated 29/4, my lord. It is.
Given you'll accept, please.
The two grounds that on which the order was passed was excess availment of input tax wrongly claimed and ineligible ITC, my lord. But we've challenged it on two grounds, my lord. First ground is limitation to issue the notice. My lord, they were supposed to issue the notice within 3 years, but by a circular, it was extended to 30/4/2024. If my lord sees page 59, my lord, it's the postal cover that through which we received this order. And on the backside, if it is seen that this postal cover, the post was booked on 4/5, my lord, which was way past the time. Further, my lord, we received a copy of this order by email dated 4/5, my lord. We have produced that email as well at page 57, my lord, which is way past the time of issuance. Further, we have received only an unsigned copy, my lord, which clearly shows that this order was only issued to us post the extended period, which was 30/4/2024. It was issued to us only post 4/5/2024, which was received by us on 8/5, my lord. Limitation, they're clearly barred by limitation, my lord. That is one ground. Second ground, my lord, the order itself wrongly takes into account there is a mismatch between the GSTR 2A and 3B, my lord.
Now let them file their objections.
Please, my lord. My lord, we have also furnished certificates from our suppliers also in consonance with the circular, showing that they have paid the tax, despite which the order came to be passed as well. We have produced 4 of those certificates along with the petition as well.
In the point of limitation, what is the provision?
7310, my lord. And there was a circular dated 28/12/2023, 56 of 23, my lord, which extended the period of issuance to 30/4/2024. However, in this case, it was issued only on 4/5.
Email and the post were after
the
30th
limitation.
photo.
Yes.
In light of the contention of the petitioner that the order ought to have been passed in terms of section 7310 by 30/4/2024, which was the extended period in terms of the notification dated 28/12/2023. And in the present case, in term as evidenced at annexure J, order was posted only on 4/5/2024 and email also received subsequent to 30/4/2024.
Please.
The proceedings ought to be set aside, subject to further consideration in light of the contentions raised. There would be stay of
Annexure A, my lord.
Annexure A. United Council G1 accepts notice for the respondent. Statement of objections to be filed. Liberty is reserved to move for modification of the order upon filing statement of objections. I1 of 24 is allowed. Petitioners dispense with production of certified copy of Annexure A.
Obliged.
Challenging the adjudication order. Input tax credit is being disallowed. Input tax credit under GST has been disallowed on the ground that there's a mismatch between GSTR 2A and 3B, my lord. My lord, meanwhile, it's an ex-parte adjudication order, my lord. The notices were not being properly served on the petitioner. It was sent only merely sent through email as well as merely uploaded in the GSTR portal. Hence, they could not participate in the adjudication proceedings. If an opportunity is granted, we'll put forth our contention before. Well, I'm placing my reliance on the Madras High Court judgment.
On what point?
On service of notice. At paragraph number 21. Paragraph number 20. Page 11. If notice sent to the designated or registered email IDs as contemplated and.
Any of that we'll see.
They don't want to respond to 5 notices.
The
Notice has been issued prior to issuance of DRC 1A. Then DRC 1A is issued, they don't respond. DRC 1 is issued, they don't respond. Now, my lords, they come up before the court and blame the officer. My lords, may kindly turn to page 34, my lords, observations have been made. That's about it. On scrutiny of the returns furnished. On scrutiny of the returns furnished by the taxable person under section 61 of the Act, it was noticed the taxpayer has short declared outward taxes at GSTR 3B as compared to GSTR 1 for the said period and also claimed excess ITC of GSTR 3B as compared to ICT available in GSTR 2A for the said period. In view of the above description, the taxpayers was provided opportunity to file explanation objections through form GST AST 10 dated 5/10/23 served on the taxpayer through registered email address. Hence, no replies filed. Again, my lords, next paragraph.
Yes. But now it's you see what.
I'll leave it to my lords. Strict directions may be given that they appear on a particular day and conclude the proceedings. Otherwise, my lords, once again the matter is remanded, they don't participate in the proceedings. We pass an ex-parte order. Again, they come back here before this court and give an explanation.
I unequivocally take undertaking.
Silence is golden.
I unequivocally take undertaking.
The petitioner has sought for setting aside of the adjudication order at Annexure C and D and consequently sought for restraint to carry out recovery proceedings. It is the case of the petitioner that though notice had been served on the email ID, the petitioner was unable to respond due to bona fide reasons and request for an opportunity to put forth his case on merits before the adjudicating authority on the ground that the petitioner has a good case on merits and would demonstrate the discrepancy between GSTR 2A and 3B. Council Hemkumar draws attention to the assessment order and submits that several opportunities have been granted. But however, admits that the order is passed in light of non-explanation of the petitioner. Taking note of the contention raised by the petitioner, as well as the submission made that they have a good case on merits. It would serve the interests of justice by relegating the petitioner to the stage of
Show cause notice.
the reply to show cause.
Reply to show cause.
Full stop. In light of the same, the order at annexure C and D are set aside. Annexure C and D are set aside, and matters relegated to the stage as referred to above. Petitioner to appear before
Respond. Only respond.
before the respondent and make out his reply by the next date. Relist the matter. Order at annexure C and D being set aside. The consequential proceedings taken for enforcement of the demand by way of attachment of a bank account as evidenced at annexure E.
Please.
Is set aside. Whenever you come in mercy, no law, you shouldn't get all these judgments.
They don't participate in the proceedings. They don't file an appeal against this order. Only after attachment notices have been issued, they come before this court, mainly on the ground that there is violation of principles of financial system.
You have to improve your strategy. Yes, next.
13, serial number 13, Venugopal.
My lords. My lords, I'm appearing in VC, my lord.
Yes.
In this case, there is a demand of service tax by comparing the income tax return and they are not, what has happened, my lord, the petitioner
Just
is.
1 minute, just 1 minute. Yes. Jivan, please. Principal Commissioner of Central Tax.
Yes.
Yes.
My lord, the demand of service tax by comparing the income tax return filed by the taxpayer, and in the state of Karnataka, they have taken registration under service tax, but they have not filed any returns. The reason is they are undertaking the fabric dyeing activity in Tirupur. They wanted to expand the business in Karnataka. They have taken the service tax registration, but they were not able to get the pollution control license, and also they have not carried out any activity in the state of Karnataka. Moreover, the textile processing activity is completely exempted from payment of service tax. All these submissions have been made, multiple replies have been filed, and despite that, the demand has been confirmed. My lord, your lordship may kindly see page 51. Page 51. This is the relevant exemption. Carrying out, your lordship got it, page 51.
Yes.
Serial number 30 of the notification 25 or 2012. Any intermediate production process as job work not amounting to manufacture or production in relation to agriculture, printing or textile processing. So this dyeing activity will come under textile processing. So it will be completely exempted. And clause C, my lord, any goods on which appropriate duty is payable by the principal manufacturer. In fact, in the reply, they have pointed out C, but in fact, I am eligible for A. That is, textile processing is completely exempted from payment of tax. And moreover, I have not undertaken this activity in the state of Karnataka. I have just taken out the registration and I have not filed any returns because I have not done any activity. All these activities, the total income, whatever I have done in the state of Tamil Nadu in Tirupur, my lord. All these replies have been filed. Your lordship will find some 4 or 5 replies have been filed. But they have not attended the hearing because from Tirupur, they said based on the reply, it can be decided. And the demand has been confirmed. I understand, my lord, your lordship has already reserved a lot of matters where the demand is based on comparison of IT return and service tax return. But on facts, my lord, my 2 grounds are: 1, I have not taken any activity. I have not taken any service activity in the state of Karnataka. Even assuming I have done, this activity is eligible for exemption. And both these pleas have been taken before the adjudicating authority, and he has rendered a finding, my lord. Your lordship may kindly come to page 52. Page 52, my lord.
Yes.
On the right hand side, there is a table. I have produced sample copies of the bills raised by me also. Whatever bills I raised for the activity which I have undertaken. And he records in the remarks column only TIN, CST number and PAN number shown in the invoice. It appears sales invoice and the same is issued to their vendor client by the assessee. Other than this, no remarks, description, whether it is fabric or otherwise, registration number, etc. found. Nothing has been mentioned in invoice regarding whether received for job work of dyeing or any other purpose. It is not even clear from the invoice that whether the details mentioned are relating to goods or services.
Just one minute. Just one minute. Can this go along with the batch?
I think it will go.
So I'll have it at 2:30.
Yes,
We have
ma'am.
prepared a list of other matters which may go along with the batch that we have decided.
Yes,
At
ma'am.
2:30, we'll take up this list.
Let him serve copies,
Yes.
sir.
Meanwhile, you can ask one of your colleagues to serve copies on G1 so
Yes,
that he'll
ma'am.
also
Yes, ma'am.
look through.
Yes, ma'am. My colleague is.
Pass over. Idu separate list.
14? 14?
14. My lord, 14 also I am appearing, my lord. This is a case under GST where the input tax credit availed by me has been denied. There is a demand under GST, my lord. The ITC availed by me has been disallowed on the ground that around 12 of the suppliers from whom I have received my input, their registrations have been subsequently cancelled by the department. So it is alleged that they are all fake traders. What has happened, my lord, in this case, a statement was recorded from me on 27/11/2020, which is at annexure C2, page number 116, my lord. After this statement, immediately I was arrested. And almost after a month or so, I got bail and I was released. And when I was in the judicial custody through my consultant, I retracted this statement also. In the adjudication proceedings, in the reply to the show cause notice, I have asked for examination of these 12% because the allegation of the department is these 12 people were non-existent. But during the relevant period, they have issued invoices to me, they have filed returns, and subsequently the registration has been cancelled. So I wanted them to be examined, all these 12 people. And these 12 peoples, I am not directly in touch with them because this iron and steel scrap trade, my lord, your lordship will be aware, there will be brokers. There were 2 brokers who have identified the sources and through whom I purchased the material. So I wanted these 2 brokers and these 12 suppliers to be examined. I made a request for examination, which was not allowed, my lord. Otherwise, the only ground which is on the basis of which the demand has been confirmed is, my lord, that this statement, 27/11/2020 statement recorded from me immediately before my arrest. And then, my lord, I am also making a legal issue. Unlike Central Excise Act and Customs Act, there is under Central Excise Act, section 9D, there is a subsection 2, which makes the statements relevant for, your lordship may kindly have a look at section 9D of Central Excise Act, my lord.
Central Excise Act.
9 capital D. Relevancy of statements. A statement made and signed by a person before any Central Excise officer of a gazetted rank during the course of any inquiry or proceeding under this act shall be relevant for the purpose of proving in any prosecution for an offence. 1 and 2 prescribe the condition. If these conditions are satisfied, the statement will be admissible for prosecution proceedings. Now kindly come to subsection 2, my lord. The provisions of subsection 1 shall, so far as may be, apply in relation to any proceeding under this act other than a proceeding before a court as they apply in relation to a proceeding before a court. So by virtue of this subsection 2, the relevancy of statement is extended to adjudication proceedings also. And there are a lot of judgments, Punjab High Court, Gujarat High Court, Delhi High Court, saying that even in adjudication proceedings, the relevancy of the statement, this section is applicable. But if your lordship compare this provision with section 136 of GST Act, with section 136,
This subsection 2, the subsection 2, which we have found in section 9D, is absent, my lord. 136. This is similarly worded. A statement made and signed by a person on appearance in response to a summons during the course of any inquiry or proceeding under this act shall be relevant for the purpose of proving in any prosecution for an offence. That is, the statements recorded under section 70 are relevant only for the prosecution proceedings, and yes, provision similar to subsection 2, which we saw in Central Excise Act. Similarly, in customs also, section 138B, customs also there is a subsection 2, which is absent under GST. So, merely based on the statement recorded prior to my arrest, the demand cannot be confirmed. This is one of the ground, my lord.
Now, in the assessment order,
yes, my lord,
they rely on this statement itself.
Yes, my lord. Yes, my lord. Other than that, no investigation. The suppliers were not investigated. The only ground is the supplier's registration has been cancelled subsequently. Moreover, my lord, your lordship,
No, let's see. Now, only on this one point you just show, because
Yes,
we're only at the stage of the
Yes, ma'am.
consideration.
Yes,
In the
26.
assessment order,
Assessment order 26 to 68, my lord. The relevant finding. Page 58, my lord. In the previous para 23.1, he deals with my request for examination of the 12 people. In para 24, the next argument raised by the noticee is that the statement of the noticee given on 27/11/2021, based on which the entire demand is proposed in the SCN, is not reliable document, as the same was obtained under duress and force. The noticee could not retract the said statement immediately, since he was immediately arrested after the deposition of the said statement and remanded to judicial custody and imprisoned. The statement of the noticee was taken by the department on 27/10/11/2021 under section 70. As per section 71 of the Act, summons can be issued by the proper officer to any person whose attendance is considered necessary, either for giving evidence or producing a document or any other thing in an inquiry in the same manner as provided in the case of a civil court under the provisions of CPC. As per subsection 2 of section 70, securing such documentary evidence.
just one.
I'm not able to hear.
To prove the existence of those persons. My lord, he could have produced it before the, my lord, the authority, or any confirmatory letters from them saying that, my lord, they are still in existence and their registrations have been cancelled subsequently. So the authority only relies on the, my lord, some investigation report stating that, my lord, registrations have been cancelled. My lord, those statements of those persons have not been recorded and relied upon by. This is his evidence, my lord, he wants to prove it. There is no question of cross-examining them, since their evidence is not recorded.
Yes, my lord. I wanted examination in chief.
Just one minute, but insofar as his contention that the statement has been retracted and that has been relied.
My lord, he retracted his statement, my lord.
No, correct. Under 136,
Yes.
he's saying that it's only in prosecution you can rely on such statement, not in adjudication procedure. Because 136 says that we'll see. If that is the only statement that they rely upon, you take your stand in writing.
My lord, what it says is, my lord,
in prosecution.
My lord, 136B, when a person who made a statement is examined as a witness for the court.
His own, correct.
No.
What is saying? His own statement.
His own statement he has, my lord, retracted.
So he's saying under 136, it's only in a prosecution for offense you can rely upon, not in adjudication proceeding.
Yes.
Anyhow, you take your stand in writing.
Please.
The counsel for the petitioner.
My lord, if lordship see this section, this is statements are recorded by in exercise of a power under section 136. Now, my lord, the 136 says, my lord, it is a summons proceedings under section 70. My lord, 136 may be read as, my lord, in addition to the adjudication proceedings, They are also relevant in the prosecution. My lord, that's how it, my lord.
That
the
may not be
interpretation-
possible, my lord, on comparison of central excise.
Can't be, my lord, it can't be only limited to
wait,
the
let us-
prosecution, because why I'm saying is this, my lord, only when, my lord, adjudication will succeed, there is a higher degree of, my lord, success in the prosecution. Prosecution alone, my lord, and can be separated, and, my lord, adjudication cannot be separated.
Is there no?
They are all
other-
part and parcel of the, my lord, the same proceedings.
No, but is there no other statement
Yes.
like 136 in the relating
In the previous, my lord, this thing.
statements made during adjudication? There's no specific provision. Is it?
Section 70, my lord, I just.
Section 70 is power to summon and they can record the statement.
Record the statement.
And the relevancy of the statement, how that statement becomes relevant, that is laid down in section 136, which is specifically made applicable only for prosecution.
Your lordships may, my lord, may make, my lord, section 70 also, your lordships may kindly speak.
Anyhow, let's see, matter requires some consideration.
Yes.
And if at all, my lord, he wanted some, he wanted to examine or he wanted to produce some evidence, my lord, he was free to do it. My lord, there's no question of cross-examining them because they are not examined.
It is the contention advanced on behalf of the petitioner that the assessing officers heavily relied upon the statement of the SSC. Full stop. Been submitted that under section 136 of the Act, reliance of statement only for the purpose of any prosecution for an offense and not otherwise. Full stop. The full stop. In light of the contention raised, legal contention raised, matter requires consideration. In the interregnum, there would be stay of
Recovery. Further recovery, my lord.
Respondents are restrained from taking steps for recovery pursuant to the order at Annexure A.
A.
Statement of objections to be filed within 3 weeks.
Sure.
Yes. Counsel G1 accepts notice for the respondents.
15, Chidanand Dallas.
I'm appearing for the petitioners, your lordship. Lordship, I've challenged the adjudication order as well as the series of show cause notices, your lordships. The issue relates to issuance of corporate guarantee, your lordship. Lordship, the petitioner issued corporate guarantee on 7th June 2017.
No, just 1 minute. For 3 and 4. 1 and 2.
One is already entered, okay.
Yes.
Two
GST counts.
Counsel G1 is directed to accept notice for respondent 2, Hem Kumar for 3 and 4. Now this corporate guarantee, some order we have passed. Same order. Same order.
Interim orders, that's it. I don't remember. my lord.
WP 16959 of 2024, that on the same assessee, your lordship, for the earlier period.
WP
6953 of 2024, your lord.
6953 of
53 of 2024, your lord.
Counsel for the petitioner submits that an identical question regarding to the same SSC for a different period has been considered an interim order passed in WP 6953 of 2024. Interim order passed reads as hereunder. In light of the same, there would be stay of
Annexure A, B, C, and D, your lord.
A to D.
16.
List along with the WP number 6953 of 2024.
Yes.
16.
This is a petition for the assessment year 2022-23, seeking refund, which although quantified for this year, is adjusted against assessment year on the basis that there is a demand for assessment year 14-15, my lords. But in fact, for assessment year 14-15,
Just repeat, just repeat.
this is a petition for assessment year 22-23, where I'm seeking a refund of the amount quantified for this year, but adjusted towards an alleged demand for assessment year 14-15. My lords, fact today is that pursuant to the tribunal's order on 22nd November 2022, which is about 1.5 years back, my lords. The assessment order was set aside and remanded for fresh consideration on various issues. After that, today there is no order giving effect passed to the tribunal's order, and therefore there is no demand in existence as of today. Despite that, the refund has been adjusted towards assessment year 14-15 where there is no demand at all. May I just take my lords?
Correct, but there's no refund also.
For assessment year 22-23, a refund is determined. May I just point out the intimation minutes? For assessment year 22-23, there is an intimation issued under section 141. My lords, after I file my return, it is first processed under section 141, and that intimation is at annexure A, page 15. My lords may just kindly turn to page 21, where the English version is available. Just at the top of the page, you have a refund for AY 22-23, and the refund amount.
No, correct, sir, but you said that on 22/11/2022 it is set aside.
No, my lords, this is the order passed in. This is the intimation issued in January 23, determining a refund. The refund is on the next page, my lords, page 23 at the bottom, 47 crores.
Yes.
Now, instead of granting me this refund of 47 crores, the department has adjusted it towards an alleged demand for assessment year 14-15. Now, my lords, assessment year 14-15, as of today, there is no demand at all. I will point that out through the tribunal's order placed at page 49, annexure J. For assessment year 14-15, originally there was an assessment made, which I appealed before the tribunal. Now, on the next page, my lords, page 51, the various issues raised before the tribunal are tabulated. I will just point out conclusion on 2 issues for my lords to be satisfied.
Now this 14-15 was set aside.
14-15 was set aside. May I just point out on 2 issues, my lords, just to demonstrate?
Just show me the conclusion directly.
My lords, on the first issue, the conclusion is on the first issue on whether there has to be a notional interest charged on the loans that I have given to my associated enterprise. The conclusion is on page 61 running up to 62. My lords.
So the entirety of the assessment order was set aside and matter remanded.
Yes, my lords. Out of the total 9 issues, 1 issue was held in my favor and the balance issues were set aside for fresh assessment. After that, no order is passed pursuant to this order of the tribunal. Therefore, today there is no demand in subsistence at all.
Lord, first is that whether the department has accepted this or appealed, that I have to be verified.
Which one?
The IT-80 order.
This IT-80 order.
IT-80. It can be challenged under 260A before.
Well, as these are
Division
remanded
bench.
issues and factually no.
And one more thing, whether order giving effect order subsequent to this,
is not
that
passed.
I have to verify, my lord.
It is not passed. My statement, it is not passed even as of today.
What is the effect? Order giving effect is not passed.
Well, the effect is that according to us, the proceedings are time barred. Therefore, there can be no order giving effect that can be passed to the tribunal's order. Today, the proceedings are barred by limitation.
So anyhow, despite that, you are entitled for refund.
Even despite all of that, the date on which they made the adjustment, there was no demand for 14-15 at all. They issued an intimation under section 245, my lords, to which I responded saying don't adjust. They had issued an intimation at page
Yes,
32.
why don't you settle it in Lok Adalat Saturday? I'm sitting in the bench. I want you to settle it.
My lords,
Unless there is some legal impediment. This will make big news.
Whether in
Yes,
Lok
Jeevan.
Adalat we can settle.
You must stand with him now on.
Yes.
No, I'm saying you examine it. I'm not saying no. We will give you sufficient time. But if legally speaking, there is no impediment, I'll have it on Friday. Look at it.
my
If
only request, my lords,
huh?
my only request, could it be taken up on 13th August before my lords? Let them secure their instructions.
No, let me see. I'm pushing for Saturday. Wait, let us see. Unless there is some legal impediment. If it requires some legal consideration, I'll adjourn it.
Please.
Otherwise, so I'll have it on Friday. You see, I'm not going to force you. But if legally it is clear, then you see if we can settle it on Saturday. Let us
take it.
Yes. You must be optimistic. If you don't support, then how they will have? Learned Council, Arvind Chavan accepts notice for respondents.
My lord, respondents number 3 to 4, my lord. 3 to 5.
3 to 5.
2 for Dilip, my lord.
Learned Council Dilip for 1 and 2.
1 and 2. 1 and 2.
1 and 2. Relist the matter on top of the list on Friday. Yes.
17, Anirudh Naik.
Or if there's any other matter, I want the revenue council to see. All of you, just see, if there's any matter that can be settled in the Lok Adalat, small matter also. Let's see if beginning can be made, which does not prejudice the revenue.
What Chandrasekhara's case, because we've been getting matters every day in and day out. That's probably someone the finance department, some of the top officers of the finance department. Settle those things, they can issue a notification. Whatever the government says, in order to settle those, that is the only batch.
Which matters?
My lord, that contractors matters, my lord, where contracts were entered into prior to GST period, then subsequent, the rates, my lord, not reflected in the contract. Subsequently, GST was leaving. That Chandrasekhara and Raju's case, my lord, that's
So then the
because all
authorities must-
stakeholders are all state government departments, those who have awarded the contract.
Yes.
My lord, the various departments of the PWD, my lord, the KPTCL, all parties are there. Now, that has to be, my lord, negotiated with the.
See, you give to the court officer any one which already notice is issued. Whatever you have, you give it, let us. Yes.
20.
My lord, in this case, challenge is to annexure F, which is a revisional order. Now, what happened, my lords, is I sent goods, intrastate transportation of goods from Bangalore to Tumkur.
Just 1 minute. Yeah, 17. Yes.
I transported goods from Bangalore to Tumkur, and at Nelamangala, my vehicle was stopped. And at that point, they realized that they do not have a e-way bill, but the goods.
Additional Commissioner of Commercial Taxes.
17th.
Pardon me? I've handed over 2 sets last time to Mr. Hemkum.
I think it's not.
Yes.
Government does not further party.
May I just point out one thing, my lords? What we are challenging is the jurisdiction of the additional commissioner to revise the order of the joint commissioner appeals. Because all this happened, I said, I have given an invoice. It's already tax paid. There is no violation by me. The goods were stopped at about, within half an hour, I have raised the e-way bill, even before the detention order could be passed, and have produced it before them. Despite that, they detained the order, imposed the penalty and the tax. I paid all of that. I go in appeal. The appellate authority, Joint Commissioner Appeals, negates this demand. Now, after 2 years, that order is taken up in revision. Now, if for a moment my lord would just take section 108 of the CGSTA, because this goes to the root of the matter, to the jurisdiction of the additional commissioner to revise the order itself. 108. My lords have 108. Subclause 2, if my lords see what he cannot revise. May I, my lords? The revisional authority shall not exercise any power under subsection 1 if the order has been subject to an appeal under 107 or 112 or 117 or 118. Now, in my case, I have gone in appeal under 107. Now, if my lords would come down and see the proviso, because the proviso is an exception to this 108 2A, proviso is an exception. Now, what does the exception say? Provided that the revisional authority may pass an order under subsection 1 on any point which has not been raised and decided in an appeal referred to in A of subsection 2 before expiry of a period of 1 year from the date of order in such appeal, or before the expiry of a period of 3 years referred to in clause B of that subsection, whichever is later.
So according to you, it's 1 year because it's 2A.
I am not on the time. I am on the aspect that he could not have revised an order on which an appellate order has already been passed.
Correct. Even otherwise, you are saying that if at all it's under within 1 year, now the revision order was passed within 1 year or after?
After 2 years later. Now, apart from that, my lords,
revision order can be passed only on the issue which is not.
When was the?
Correct. No, no,
When was-
no, no, I am on the point, my lords,
When
that
was
the
the appeal,
revisional.
when was the appeal disposed of?
Grateful. It was disposed on 21/2/2022.
And the revision petition taken up?
Taken up, I don't know, but the order was passed on 27/3/2024. The notice was dated 12/1/2024.
Anyhow, look into it.
My lords, no, what I am saying, my lords, is that he,
Look into it.
Please no, because there is no other alternate remedy against order passed by the additional commissioner. Matter will have to be considered here. And insofar as stay is concerned, my lords, I think pursuant to the order passed by the first appellate authority, they have obtained refunds of the entire money. What was paid as penalty in pursuance to the order set to have been passed on 6 months.
correct, but now they are seeking it back. They have issued the notice, which is also enclosed here.
Let's see.
My lords, there's just one more ground.
Just wait,
Sorry,
just wait.
sorry.
In light of the contention of the petitioner that appeal was filed under 107 and Joint Commissioner Appeals had disallowed the appeal by order dated 21/2/2022. And if that were to be so, no revisional power could be exercised in terms of section 108 subclass 2A. Matter requires consideration. In the interregnum, respondents are restrained from taking any coercive steps for recovery. Learned Counsel M. Kumar accepts notice for the respondent. What is the office objection? They have to do 17th. What is the office objection? The authorization letter. You will do.
It's
comply
a
with.
partnership. It's a partner and a partnership. I mean, he cannot authorize himself.
Office objection is kept in abeyance. Yes.
18.
If I recollect properly, my lords, recovery notice is issued by one of the central authority. Not even made a part.
Recovery notice.
Recovery notice, my lords, now. In pursuance to the order passed by the additional commissioner, is issued by one of the central authorities.
Annexure H, if my lords see, is issued by a central authority, but that doesn't matter because the
Then
original demand itself.
he will not be bound by the interim order, he is not a party to the petition.
Unless you make him a party. You make him.
Take the risk of not making him a party.
Make him a party
Interim
now.
order will not become-
I'll make him a party.
In light of the oral request made, the petitioner is permitted to array
Sorry, madam.
who? The
Annexure H is the
superintendent of central tax.
Sorry.
No, it says
superintendent of central tax.
superintendent of
Yes.
service tax as an additional respondent. Who appears for that?
That will be Jeevan central tax. Superintendent of central tax.
Council Jeevan is directed to accept notice for the newly added respondent. Necessary amendment to be carried.
Deeply oppressed.
18. 18. Raghavendra.
Joint Commissioner of Commercial Taxes and CTO. Yes, what is the matter?
Yes, Your Lordship. In this case, Your Lordship, on 30th May 2024, the goods have been seized by the commercial tax officer without there being an order of detention, Your Lordship. In terms of section 129, Your Lordship, if they are detaining or seizing any goods, they have to pass an order before seizing of any goods, Your Lordship. But in this case, Your Lordship, after almost 4 days, they have passed an order. As on the date of seizure, they have not passed any order of detention. In fact, Your Lordship, similar matter came up before the Dharwad bench of the Honorable High Court. And the Dharwad bench of the Honorable High Court, Your Lordship, has granted a interim stay for release of the goods by considering the proviso to section 129 clearly holding that there was an illegal detention of the goods. I'm just passing on the order.
Let us see, let them come back with instruction.
I'll come back with instructions.
Okay.
Proviso says no goods or conveyance shall be detained or seized
without serving
an order of detention. You
Please.
find out.
Please.
Counsel M. Kumar accepts notice for the respondent, relists the matter in the orders list on
16, huh?
16. Yes.
19, serial number 19.
This matter is similar to item number 16 for the same entity for a different year, 2 different years refund adjusted against assessment year 13-14, when even for that year there is no demand.
Counsel Arvind Chavan accepts notice for the respondent. Relist the matter. I'll have it on Friday, but then we'll tag both and see. List along with serial number,
Item number 16, Alex.
item number 16.
Date petition 16-840 of 2020.
What is the non-compliance?
My lords, the objection is that, my lords, the first prayer, we have sought for quashing of the adjustment, but there is no annexure referred to over there is the objection.
So then you comply with that. There's no annexure.
No annexure, there is nothing for me to demonstrate that an adjustment has happened by way of
Officer, objection is kept in abeyance.
20.
I'm appealing to the petitioners, Your Lordship, this issue relates to the works contract service rendered by the petitioner to all the government organizations, Your Lordship. I have paid the tax to the government, but these government organizations are not paid my tax. It's based on the Chandrasekharaya, Your Lordship, please.
You take out notice.
Your Lordship, there are 20 respondents to government 1 to 22, Your Lordship. All the government authorities.
You just show it to him. M. Kumar, just see.
Can accept notice for respondent.
All state, all the government organizations.
One.
We paid the tax.
4.
State authorities.
No, executive engineer, all state authorities, but
No, municipal commissioner, they have the separate councils.
2 is given as to accept, it is Commissioner of Central Tax.
No, just.
No, this is
just one.
20,
just
this is not.
Just one. Different filing.
But we have a 20. You can't export it.
Tax authorities, central tax authorities are not.
My lord, I've not made central tax authority the party because I've already paid the taxes. The government has not given me the tax of 12%.
Emergent notice petitioners permitted to serve the standing counsel, if any, for the respondents. This is the matter week after next. Yes.
Like
21, Naveen GS.
Appearing for the petitioners, my lords. My lords, this is a matter regarding a transitional GST period. And my lords, the petitioners are squarely covered in the judgment passed by the coordinate bench in 9721 of 2019, my lords.
Now, who appears? Commissioner of Central Tax.
Madam, just last action. I pay for respond number 2, my lords.
Respondent number 1 and 3 to 8, my lord.
Joint Counsel M. Kumar accepts notice for respondent number 1, 3 to 8, 3 to 8. Then council G1 accepts notice for the second respondent.
My
Is,
lords,
what is the interim, interim?
my lords, DRC 7 orders have been passed and there's an apprehension that there will be attachment of bank accounts. Hence, we request that no recovery proceedings are to be proceeded
Where is
with.
the interim order in the other matters?
My lords, 9746 of
Page?
2024, 131. ma'am.
The counsel for the petitioner submits that identical, in an identical matter.
I don't think any orders have been passed. Why prayer?
So I'll only say no coercive steps for recovery.
But that should not deprive us of passing orders.
My lords, it's very well covered within the ambit of 9721 of 2019, wherein the petitioners were required, were supposed to reimburse the GST amount, my lords. We have made the representations. And my lords, your lordship in the judgment of 2130/2022.
So anyhow, you consider if no step, no coercive steps, I'll only say no.
My lord, that Chandrasekhara judgment, they are being relied upon. That one of the connected matters, my lord, division bench of this honorable court has already issued a notice.
My lords, even the petition.
The delay, that's why, my lord, the court has issued a notice on that.
My lords, the said petitioners were.
Just wait.
That's the development. my lord.
The problem is that the contract is extended to between of the government agencies, either PWD or PWD or CARIDS or any other government agencies, but with some of the associates or contractors. But now that contract has to be amended. So my lords, kindly see the previous here.
And we have issued orders to amend the contract.
Yes. Number one, to give the difference.
No, that's what, no, my lord, the time limit was fixed under that. 6 months. That also expired, my lord. No one has come.
There's no amendment.
They did not approach 1 or 2, except 1 or 2, my lord, no other petitioners have approached the authorities seeking, my lord, revision of rates or amendment.
In fact, respondent number one in this petition, the state of Karnataka Department of Finance, they are in no way involved in entering into a contract.
My lords, if I
But
could make a
there is
kind
an
submission.
abuse against them to refund the amount.
My lords, if I could make a kind
Just
submission.
wait, just. So you're saying they can go ahead in the adjudication, but recover, post that recovery is to be stayed.
In fact, my lords, in some of the orders, officers have passed levied taxes, but have made a mention saying that in view of the law laid down in Chandrasekhara's case and in view of the return being pending, this demand is not being enforced for the moment and it will be kept
In abeyance.
in abeyance till the matter is decided for the day.
So I'll restrain them from taking any recovery steps.
My lords, if I
During
could
the
make one
process.
kind submission.
Huh?
my lords.
Yes.
One submission. My lords, your lordship in the writ petition number 2130/2022, your lordship, I have the judgment as well, my lords.
What is the name of the party, madam? Raju.
Yes, Kumar.
Kumar Swamy, yeah. Same.
My lords, in the said judgment as well, your lordship had passed an order stating that wherein the directions were issued to the respondent, that is the state as well as the government entities, to reimburse the said amount, to enter into supplementary agreements, to consider the representations, my lords, as well as that no coercive steps were
Let
are
us
to be
see,
taken with.
let us see. Now anyhow, they are not, they say they filed an appeal. They will not be in a position to recover unless unless there is an order by this court permitting recovery. So if they want to finish the adjudication process, you place all contention will be kept open. Let us see.
My lords, one more submission. If you
Now
could
it's still
kindly
at the
refer to
show
page
cause
14.
notice stage.
No show cause notice has been
It's there, it's there. Annexure C,
Annexure,
Annexure C, the notice as well as orders.
order is passed.
Yes, my lord, page number 64 to 117.
Page?
C. 64 to 117.
So we'll say no coercive step pursuant to Annexure C. Isn't it?
My lords, one more submission, my lords. If you could kindly refer page number 14, my lords, of the petition. Para number 16. There are two assessment years, 17, 18. My lords, the same petitioners were also part of the 9721 or 2019, the batch matters, my lords. They are very well covered within the ambit of 9721, my lords. As well as, my lords, if you could kindly refer page number 14, my lords, of the petition copy.
Now the order of adjudication is under 73-9.
Yes, my lords.
So we'll stay that for the time being. We'll see.
My lords, one last submission, my lords. Page number 14, my lords. My lords, para number 16, it is stated that even this honorable court in the matter of AB Construction was Assistant Commissioner of Local GST. This honorable court has even set aside the pre-intimation notice, show cause notice, and the reassessment order, relying upon the decision writ petition number 972.
Right, so that's the final order to be passed. Now we are still at the interim stage.
So, my lords, the thing is like, we are very well covered within 971,
Yes,
my
yes,
lords, and
yes.
hence a prayer be
So
considered.
we're giving you interim relief.
Grateful.
There would be.
Lords, may I kindly see that, my lord, the judgment of my lords on this 2130 of 20 is passed by this honorable court. Just for a moment. That not in the writ petition papers, what my learned friend has handed over that. my lord, judgment.
Yes.
The page number 42.
I don't know how we could have passed such orders. Anyhow.
Yes. 42.
We can't compel any authority to
Yes.
exercise contractual power.
My lords,
That's what, my lord, on that basis, my lord, the division bench has issued a notice.
my lords,
It virtually amounts to a
Correct, but
rewriting
you
the law.
must, correct, you must challenge the first of the orders.
First order.
Because
Chandrasekhar is
the
order.
others orders,
That is challengeable. In that only notice has been issued.
because even we do copy.
The lordships have followed that earlier judgment. But lordships mechanism, the last paragraph on page 42, petitioners are directed to submit comprehensive representations to the respective employers, respondents within a period of 4 weeks from the date of receipt of copy of this order, irrespective of whether they have completed the works pre-GST or post-GST, or payments are received or yet to be received. If such representations are submitted, the respective employers, respondents are directed to consider and dispose of the same in the light of the aforesaid direction, so and so, within a period of 8 weeks. Now, in view of the interim orders passed by this court in the present petitions, such petitioners who had not filed GST returns so and so are permitted to file their returns, amend returns pursuant to the calculation of the differential tax. GST authorities are directed not to take precipitative action against the petitioner for a period of 6 months from the date of receipt of the copy of this order. This is the order. Now, in compliance with this order, nothing has been done by them.
my lords, if I could
Now, my
also
lord,
make
this
a
benefit
submission.
of this order, my lord,
My lords, the order also states that reimbursement has to take place. The supplementary agreements are to be executed, my lords.
No,
But I
have
was
you made-
letting go of
correct.
that perspective, my lords, and just concentrating on the fact that within
Have you-
6 months.
Correct,
first
correct.
six
That
months can
we'll
be
see.
taken.
Have you made representation at
Yes,
least?
my lords, very well, we have made the representations. It's
Okay,
an
let us-
annexure B.
Let us,
Annexure B.
we'll
page
see,
number-
in light of the contention raised, that the legal issue is covered by the directions passed in WP 2130 of 2022 and connected matters. There would be stay of recovery.
contractee has not been made as a party.
Huh?
My
The
lords,
person who awarded the contract has not been made as a party in this writ petition.
my lords, the reason why we have
In fact,
not
he is
made them
the
parties
necessary party. He is the
But-
necessary party.
You have to seek for amendment of the contract in terms of the observations made.
Yes.
And in the interregnum, seek for stay of recovery.
My lords, also one of the reasons why we have not made the contractors as a party is because if the state itself, if the finance department itself comes up with a circular, that would have a binding effect on all the contractors, my lords. That's the reason why they have
No, no,
been the
we-
parties, my lords.
We agree with
If
you.
there is no circular on place, my lord, the contract, we have made the representation.
Let us see.
Two rounds of representations, my lords.
No,
None
that-
of it was considered,
that
which is
will
the
see.
reason why we have made the
That
first.
will see. But
state
now
as party.
I'll permit you to amend. You'd carry out the amendment. The petitioner is permitted to implead the contracting parties as additional respondents. I'll have it on Friday.
Kindly, my lords, the stay order may be good for the interim order. No precipitative actions to be taken.
Necessary amendment to be made. In the interregnum, respondents are restrained from taking any steps for recovery pursuant to the orders at annexure C and
C.
C.
Annexure C1 to C3.
C1 to
T3.
C2. Relist the matter on Tuesday, only for the limited purpose of amendment.
Grateful, my lord.
22, Praveen Kumar.
The respondents are reserved liberty to seek for modification of the interim prayer upon completion of instructions.
that extent.
22, Raman Kumar?
My lords, I appear for the petitioners, my lord.
Yes.
In the present matter, we are challenging the notice cum order issued by the respondent under section 148A clause D, my lords. My lords, quickly in a minute, I'll explain the facts that has transpired, my lord. In the year 17, 18, 19, the petitioner had borrowed loans to the tune of 7 lakhs, which he could not repay. For that sake, he was withdrawing money from his credit card and he was paying the installment of the original loan, my lords. Whereas the burden of loan shifted from loan to the credit card. This cycle continued, my lord, from one credit card to another credit card, it continued. And this explains the transaction that the banks have reported, my lords. Pursuantly, he of demand notices from the banks. Later on, under one-time settlement, the banks offered him to settle the outstanding dues at 10 lakhs, my lords. His family members bailed him out by paying 10 lakhs, which he repaid by selling the immovable property, ancestral properties, my lords. Pursuant to this, my lords, in the year 24, that is on 13/3/2024, preliminary notice under section 148 clause B was issued, my lords. It is in annexure E. My lords, in this notice, the respondents have given only 8 days of time, my lords, ignoring the fact that the amount of explanation they have sought comes to the tune of 1 crore 3 lakhs and it involves 4 different banks, my lords. It was humanly impossible for the petitioner to reply under such short circumstance, such short period, my lord. Within the expiry of 8 day, my lord, on 25th March 2024, the respondents have passed the notice along with the order under section 148 clause D, my lords. It is in the annexure A. At the outset, my lord, this notice itself is illegal, my lord. I'll demonstrate, my lord. Please come to annexure A, page number 22.
Now, where's the 148 AB notice?
It is in annexure E, my lords. Page number 63. In para 3, they have mentioned you are required to show cause as to why in view of the details contained in enclosure mentioned in point number 1 above as a notice under section so and so should not be issued. You may be
correct. Now, what's the point you're saying?
My lords, if you come to the pursuant to this notice, my lord, they have issued notice on 25th March. That is in annexure A, page number 22, my lords. The contention that this notice is document is digitally signed. Please refer digitally signed, digital signed signature at the bottom of the page. Now, when we see the bottom of the page, my lords.
Let it go back at the 144, 148 AB notice.
AB notice.
Yes, because he has challenged the AD order only, because he is not having much sufficient time to.
My lords, the notice itself is inoperative, my lords.
Prayer is to quash the AD order. So let it go back to the AB stage.
Yes.
My lords, if we see the signature part, the digital signature, which says in the right-hand side, end of the notice, this document is digitally signed. Whereas if you see, my lords, there is a question mark along with the photo and image which shows. That means the identity is not valid. This digitally signed signature is not at all valid, my lords.
All this, we'll let him contend this before the authority, because that is, let him take a clear copy of the 144A,
My lords,
AB notice.
when the competent authority has not even signed, how such?
The challenge is only to the AD order.
That is the pursuant order, my lord. When the order itself falls, when the order itself falls, the prior notice does not survive, my lords.
It is only a soft copy, my lord. Let him go and take it. Where in the
No, you suppose 148.
It's all signed by, that is a digitally signed order. Notice.
148.
My lords, in fact, it's not digitally signed, my lords.
It is a digitally signed notice. And anyway, since his prayer is only to quash AD order, he has not been given sufficient time. Let it go back at that stage.
Now here reassess 147 order is passed, no.
No, my lords.
So only 148 notice is issued.
148
There is-
notice was issued, 148A clause D order was issued to pursue the matter, wherein the petitioner was directed to file income tax returns. My lords, I can argue in that point also, my lord. The petitioner is not at all liable to file the income tax returns, my lord.
That is on merits that we can't.
That is not,
That is on
cannot see
merits.
here.
If you want
No,
to go
explain.
back to the stage of 148 AB,
AB, no.
we'll send it back.
Yes.
Everything else will go. There you take your step.
Yes, my lord. Please.
But in 144 AB, 7 days.
No, 8 days.
7 to 30 days maybe.
8 days time is given. Anyway, your lordship is going to send it back.
My-
to him.
my
Let
lords.
him appear. On a given date, let him appear and file his submission.
Now 8 days notice is given, but you said.
My lords,
Huh.
8 days time was given. In the year 2008, the petitioner have shifted to Bangalore. The address of the petitioner mentions Chamarajnagar district, Kollegal.
You were not served, is it?
I was not served. I was served, my lord, but belatedly. The postal department redirected the post to Bangalore. It took 4 days, my lord. Where itself 4 days expired and remaining 4 days, it was humanly impossible to get transaction details from all these 4 banks. my lord.
Petitioner has sought for setting aside the order, setting aside the notice under 148 at annexure A. Full stop. It's further contended that in light of technical defects such as non-signing of the notice under section 148, same is required to be set aside. At the time of hearing of the matter, petitioner also seeks to assail the order passed under 148 capital A small d at annexure.
A, my lords.
No, D, AD.
Yes, my lord. D is in annexure A, my lord. 148 AD. Notice come order. Both was issued in one notice, my lord. The first page is the notice, second page is the order.
A capital A small d. But he has to make some amendment, isn't it? Because he has not assailed that, nor has he made it as an annexure.
AD's order is at page 23.
Page
my lord.
23.
But he has not assailed it.
Yes, yes, yes.
ಏನ್ ಬರ್ತಿದ್ದೀವಿ?
What is this annexure?
At least he'll have to make it as a.
No, he has made he made them together, he has made them
As a-
annexure A.
Collectively.
A. So it annexure A continues from page 22 onwards. Both the things here, common annexure.
You will make, you make it as A and A1.
A1.
You make 148 as A,
Yes, my lord.
148 AD as A1.
A1. Yes.
Corrected here.
Yes.
Huh. At annexure A1.
A1.
Full stop. Such request is made. Such oral request is made at the time of hearing of the petition, and petitioner was permitted to amend the prayer column as well as assign separate annexure number to the notice under 148 capital A small b.
No, my lords, the AD order at as annexure A1.
A1.
It's very,
Page 23.
23.
ಅದು A1 ಏನ್ ಬರ್ತಿದ್ದೀರಾ? To the order under 148 capital A small d. Next. It is the case of the petitioner that the notice under 148 capital A small b, though issued on 13/3/2024, seeking for response on 21/3/2024, reached the petitioner belatedly, as the same notice was redirected to the petitioner's address at Bangalore. And accordingly, the time available to make out reply to the 148 capital A small b, in effect being less than 7 days, has caused serious prejudice.
It is 8 days. 8 days, my.
No, in effect, has caused serious prejudice. He submitted that if the petitioner is afforded an opportunity to make out his reply to the 148 capital A small b notice, petitioner would be in a position to demonstrate that proceedings are required to be dropped. Taking note of the contention raised, matter requires reconsideration by relegating the petitioner to the stage of reply to 148 capital A small b notice. Accordingly, the notice at annexure A and the order at annexure A1 are set aside. Matters relegated to the stage of reply to 148 capital A small b. All contentions are kept open. Next. Though the petitioner had initially assailed only the order at under section 148, however, at the time of hearing of the matter, case is made out for affording an opportunity to the petitioner to make out reply to 148 capital A small b notice, and accordingly the consequential proceedings are set aside, though all contentions are kept open.
Let him appear on a
The
4 weeks time.
petitioner to appear before the second respondent.
Second respondent.
On 4 ವಾರ ಆದ್ಮೇಲೆ ಡೇಟ್ ಕೊಡಿ. 5th of August.
5th of.
You carry out that amendment in the prayer column and the annexation.
Yes, my.
23 published, Srihari.
Kindly pass on.
Pass over.
24.
I appear.
Matter relating to GST. Essentially, I'm a developer.
Just 1 minute. Yes.
But R1 is Union of India. R2
and
State
3
of Karnataka and
state-
commercial tax.
State authorities. And Land Council Shamat Naik accepts notice for respondent 2 and 3. Land Council Union of India. B promotes the right to accept notice for the first respondent. Yes.
I'm a developer who constructs and sells apartments. I've charged 2 different considerations, one for sale of land and one for construction activities. Sale of land is exempt, not liable to GST. So I paid GST on the construction value. The contention of the respondent is I take both sale of land and the construction value together and take 1/3 of total value deduction and pay GST on the balance of 2/3 balance. This is as per the notification.
Now there are 2 agreements, construction
and sale of land. So sale of land, I charge A amount and construction amount is B. So I have paid GST on B amount. The contention of the respondent is, I had to add up A plus B, take 1/3 deduction in terms of the notification, and pay GST on 2/3. This differential amount is the demand which is raised, my lord. Consequently, the notification which requires me 1/3 deduction and the assessment order are under challenge. My lord, this issue came up before Gujarat High Court, and Gujarat High Court has held that this notification giving 1/3 deduction is ad hoc. Therefore, it has been held to be ultra virus, the provisions of GST. But considering that decision, in my own case, for the earlier period, 17-18, interim orders have been passed by this honorable court.
Annexure?
Annexure.
Page 299. Annexure K.
299, paragraph 2, ma'am.
The petitioner submits that in the case of the same SSC for a different period on an identical raised, this court in WP 24792 of 23 has passed an interim order, and on parity, petitioner is entitled for the same nature of interim order in the present case also. Order passed in WP 24792 of 2023 reads as follows. In light of the same, there would be an interim order of stay of
Annexure A, my lord.
Annexure A. This is the matter along with WP number 24792 of 23.
Obliged.
Statement of objections to be filed. Respondents are at liberty to seek for modification of the interim order upon completion of instruction.
Party model.
Yes.
25, Chetan.
Should pray for 2 weeks' time, my lords.
Just after 2 weeks at request.
26, Anil Kumar B.
May I please, my lord? I am appealing to VC. But am I audible, ma'am? But am I audible, ma'am?
Yes, yes.
Yes, ma'am.
Commissioner of Commercial Taxes.
I'll take
Yes.
notice, my lord.
Yes,
Learned Counsel Shamant Naik.
my lord, there's a bank attachment and my lord, violation of natural justice.
Yes.
My lord, it's a very short point. My lord, DRC 07 order has been passed pursuant to my lord audit. My lord, without granting me personal hearing, my lord, which is mandated under section 75, subsection 4.
Yes.
My lord, what I did, my lord, the order dated annexure A 20, my lord, it is dated 22/12/2023. My lord, certain vital points were not considered. So therefore, my lord, I filed a rectification application, my lord, under section 161. My lord, that has also been, my lord, disposed of, my lord, without any reasons, my lord, and a very, very brief order has been passed. Now, that order, my lord, is in page number 41. There, my lord, there's no discussion at all. I wanted them to consider, my lord, the dates of agreement entered into and the type of agreement and the tax paid. Nothing is, my lord, there in that rectification order. And my lord, the first order dated, my lord, 22/12/2023, admittedly has been passed without granting even one hearing. So if your lordship pleases, my lord, on that point, if it can go back, my lord, I'll be grateful. But on merits, my lord, I have a stronger case because what they have done, my lord, they have tried to artificially club four contracts into one. And my lord, they're saying that it is a works contract, therefore, my lord, pay tax. My lord, I have developed solar power project for a client. My lord, normally a lordship knows at the bidding stage, my lord, we only go by the numbers and the timeline, technical specification and all of that. And my lord, particularly L1, L2, all that, my lord, process will happen. At the time of awarding contract, my lord, typically, my lord, especially from the income tax TDS perspective and all that, but separate contracts are always awarded, one for supply, my lord, other for erection, installation, commissioning, my lord, other for construction, my lord, civil construction, all of that. So in my case, my lord, there are 4 contracts, all dated 7th November 2017. You know, the first contract is for supply of goods. You know, that I have paid 5%. There's no quarrel on that. The other
Just
rest
one-
of the,
You take instructions.
Yes, my lord. Wednesday, my lord.
Yes.
well, they've attached my bank account. Well, they're not violation of natural justice. 20 annexure A order, my lord, passed without granting personal hearing. My lord, directly, my lord, against section 75(4).
No, on Wednesday we'll consider. We'll
Next
consider it on
Wednesday.
Wednesday.
Well, Wednesday, I thought it was a holiday. Madras High Court is closed.
Tuesday.
My lord, if your lordships will not work, if it's 17th, the working day, I'll come. My lord.
Tuesday.
Yes, 16th, yes, I'm grateful. Now, the office objection is only, my lord, for a minute, my lord, Lordship, kindly see page, annexure B, 41, 42. There's no signature, my lord, that is how I have received.
Office objection.
My lord, in page 41 and 42, that 42 annexure B order, which was under challenge, it was sent to me by through an email, my lord, which is page number 82. I hope my learned friend, my lord, will not object.
Office objection is kept in abeyance.
I don't know, my lord, if he confirms, well, then it may be page
This is the
82, 80.
matter in the orders list on 16th. On 16th. Yes, 16th we'll see.
Yes, well, I'm grateful.
27. Till number 27.
Okay, for the petitioner's counsel, matter relates to GST on, my lord, service tax on royalty that, my lord, seized off by the Honorable Supreme Court. Interim orders are passed by the Honorable Supreme Court. Your lordships, my lord, have followed that and passed interim orders. Give me the order.
Yeah.
That's my copy. Where are the other
Submitted that,
Lord, and these are the orders passed by your, my lord, this court. Sorry, at the same. Same.
Yeah, they submitted that
Interim prayers at page 31. I've sought for, my lord,
royalty on mining /
this is, I think, quarrying and stone crushing.
royalty on mining /
In my case, I'm stone crushing, but nonetheless, it falls under the same bracket.
mining lease royalty grant service tax on mining lease / royalty is a matter pending consideration before the apex court in which interim order is passed, and the questions raised by the petitioner come within the purview of question being adjudicated before the apex court. So in light of the submission made and taking note of the order of the apex court in WP within brackets civil 1076 of 2021, there would be an interim order of stay of the GST on royalty.
GST on royalty and annexure Q, my lord, that's the demand.
And demand at annexure Q. Stop. Any payment? No. Yes. But it was some.
Lord, what happened was there was some audit in that
Lord,
these remarks were raised and I
the
responded.
Stay, let it be related only to mining, my lord. If there's anything else that is.
Fair. Mining royalty, your lordship, whatever is covered by the ambit of the order, I'm protecting.
Confined insofar as is confined to demand as regards GST on royalty.
Royalty, great.
But some orders were to be pronounced, isn't it? Apex court reserved.
Seized off the matter.
Lord, I'm told it's not
Awaited.
yet come up for hearing.
Still awaited.
Ravinder Singh's case, it's not yet come.
Yes.
And do they, great.
28. Sandeep.
But serial numbers 28, 36 and 39. Your lordships will recollect last week. I submitted regarding these Wipro group companies, my lords, the lordships of
36
and 39.
Yes.
In 28, my lords, I think Mr. 28, Mr. Thirumalesh for R2 to R6. And 36 and 39, Sanmati or Sushal Tiwari.
Yeah.
My lords were pleased to pass an interim order last week. My lords, say exactly the same. There's no difference. These are all group entities. Identical issue regarding the validity of a 148 notice. Your lordships may recollect, I submitted that it's beyond the period of limitation prescribed under the proviso read with the erstwhile provision. Same order, maybe.
Yes.
No.
Then senior
R1,
counsel
let's say
appearing
same
on
order.
behalf of the petitioners submits that an identical issue, a subject matter of WP 17284 of 2024, in which interim order has been passed. The interim order passed reads as hereunder. In light of the same, there will be an interim order
Of annexures A1 and A2.
annexure A1 and A2. So in 28, who accepts
Mr.
notice?
Tirumalesh.
This is
From 2 to
Tirumalesh.
2 to 6.
Accepts notice for respondents 2 to
6.
2 to 6. Union of India,
Mr. Pramod, I think, your lordships are directed.
B. Pramod is directed to accept notice for the first respondent. Then 36.
36, R2 to R5, that's the one difference, and Mr. Sanmati can take notice. There are only 5 respondents in there, so R2 to R5.
In 36, R2 to R5, Union Council Sanmati is directed to accept notice. R1, B. Pramod.
Yes.
Same interim.
Same. And 39, R2 to R6 again, Mr. Sanmati.
R2 to R6, Union Council Sanmati. R1, B. Pramod. Same order.
Same order. It may be connected along with this. I think your lordships already connected the previous matters. It also may be connected.
39 and 36 to be called along with serial number 28.
Along with also, my lords, the interim order I just passed on, because all of them identical issues.
All these matters to be called along with WP 17465 of 2024.
Obliged.
29.
May I please, Your Lordship? This is challenging the draft assessment order annexure B and DRP directions annexure D. If my lords kindly take section 144C for a moment.
Just 1 minute.
Yes.
Tirumalesh, you accept. Council Tirumalesh accepts notice for respondents 1, 2, 3. Yes, section
144 capital C.
(144)
Capital C. Reference to dispute resolution panel, my lords, are there?
Yes.
Subsection 1 says the assessing officer shall, notwithstanding anything to the contrary contained in this act, in the first instance, forward a draft of the proposed order of assessment, hereinafter referred to in this section as the draft order, to the eligible SC if he proposes to make on or after 1st October 2009 any variation in the income or loss returned. So basically 144C requires, my lord, a draft order to be passed in the case of an eligible SC. Now, my lord, eligible SC, if my lords kindly see subsection 15. My lords have subsection 15 of the same section.
Yes.
For the purpose of this section, clause B says, eligible SC means any person in whose case the variation referred to in subsection 1 arises as a consequence of the order of transfer pricing officer passed under subsection 3 of section 92 CA and any foreign company. So only in 2 cases, a draft assessment order under 144 C1 is required to be passed. One is, first I have to be an eligible SC. Now I become an eligible SC, my lord, if a transfer pricing order or an adjustment is made under clause B, subclause 1, or I am a foreign company. I am not a foreign company, I am an Indian company. And in this case, although a transfer pricing order was passed, if my lords kindly see annexure A, page 14, although a reference was made to the transfer pricing officer, no adjustment was made by the transfer pricing officer. my lords kindly take Annexure A, page 14.
Yes.
And if my lords kindly come to page 15, para 2.
Yes.
The taxpayer filed submissions dated so and so in response to the above notices. After carefully considering the material on record, it is concluded that no adjustment is required under section 92 CA, read with section 92 C of the Act, to the arm's length price determined by the taxpayer in respect of the international transactions entered into with the associated enterprises during the year. So transfer pricing officer, although a reference was made, no adjustment. Therefore,
So you're saying if there's no variation, you don't come
if
under
there is no
B1.
variation, they have to directly pass a final assessment order under 144(3), a regular assessment order. They could not have passed a draft assessment order under 144(c)(1). If my lords kindly see Annexure B, page 16, they pass a draft assessment order.
Yes.
And I challenged this draft assessment order because the draft assessment order says I have to file.
Yes.
Yes.
In light of the contention, I've learned senior counsel appearing for the petitioners that the procedure under 145C of passing
44, my lord.
144C of passing draft order would not apply, as the petitioner is not an eligible SSC. Matter requires consideration, full stop. It is pointed out that for a draft order to be passed under 145C, the petitioner ought to have been an eligible SSC, wherein a variation is sought to be made in terms of 144CB Roman 1. And in the absence of such variation, as is evident from the order at Annexure
A, my lord.
A, the procedure under 145C of passing draft order.
144, my lord.
144C of passing draft order would not arise. In light of the contention raised, there would be stay of
Annexure D, DRP directions and the proceedings consequential thereto.
Annexure D and the proceedings consequent thereto. Yes.
Grateful.
30, Karan Kumar.
Lord, appear for the petition. Lord, petitioner is a society running a school, my lord. Lord, it is running school classes 1 to 8, my lord, with recognition. Now, my lord, it has also applied for starting classes 9 and 10, which it has already been running. Now, my lord, the recognition for classes 9 and 10 has been refused on the ground that, my lord, the school has not obtained conversion certificate to the effect that it can be used for educational purposes. The land, my lord, which is contrary to the rule itself, my lord, kindly see page number 25, my lord. My lord, page 25. Amendment of Rule 3, that is Rule 3 in Karnataka Educational Institutions, Classification, Regulation and Prescription of Curricula, etc. Rules, 1995. My lord, kindly see the amended rule. Provided that if the management which is already running primary school, that is from classes 1 to 8 or from 6 to 8 in the same premises, submits an application for registration and recognition of class 9 and 10 in the said premises, it shall be deemed to be considered as upgradation or continuation of education for the purpose of registration and recognition purpose only. My lord, this is the same, my lord, which could be found in the circular at Annexure K. In Annexure K at page 29, my lord, the same provision is reiterated. Actually, the circular is still more clear, my lord. May I read? Page 29.
Relevant portion.
Yes, my lord, the relevant portions. I will read only relevant portions. My lord, Karnataka Shikshana Kaide 83 section 30 ಮತ್ತು 31 ಅಡಿಯಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ
ಕರ್ನಾಟಕ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಗಳ ನಿಯಮ 97ರ ನಿಯಮ 3ರ ಅಡಿಯಲ್ಲಿ ಹೊರಡಿಸಲಾದ ಉಲ್ಲೇಖ 1ರ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಮಕ್ಕಳ ಉಚಿತ ಮತ್ತು ಕಡ್ಡಾಯ ಶಿಕ್ಷಣ ಹಕ್ಕು ಕಾಯ್ದೆ 2009ರ ಸೆಕ್ಷನ್ 19 ಮತ್ತು 25ರಲ್ಲಿ ಶಾಲೆಯು ಹೊಂದಿರಬೇಕಾದ ಜಮೀನು ಸೇರಿದಂತೆ ಶಾಲಾ ಕಟ್ಟಡ ಹಾಗೂ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ಮತ್ತು ಉಲ್ಲೇಖ 5ರಲ್ಲಿ ಹೊರಡಿಸಲಾಗಿದ್ದ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಹೊಸ ಶಾಲೆ ನೋಂದಣಿ ಸಂಬಂಧ ಅರ್ಹ ನೋಂದಾಯಿತ ಆಡಳಿತ ಮಂಡಳಿಗಳು ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಪ್ರಸ್ತಾವನೆಗಳು ಸಲ್ಲಿಸಬೇಕಿತ್ತು. ಈ ಕಚೇರಿ ಉಲ್ಲೇಖ 5ರ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಉಲ್ಲೇಖ 1ರ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಹೊಸ ಶಾಲೆ ಪ್ರಾರಂಭಿಸಲು ಅಗತ್ಯ ನಿವೇಶನ ವಿಸ್ತೀರ್ಣವನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿದೆ. ಅದರಂತೆ 1ರಿಂದ 10ನೇ ತರಗತಿವರೆಗೆ ಶಾಲೆ ಪ್ರಾರಂಭಿಸಲು ಗ್ರಾಮೀಣ ಪ್ರದೇಶಗಳಲ್ಲಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಇತ್ಯಾದಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಶೈಕ್ಷಣಿಕ ಉದ್ದೇಶಕ್ಕಾಗಿ ಪರಿವರ್ತನೆಗೊಂಡ 3,000 ಚದರ ಮೀಟರ್ ಭೂಮಿ ಸ್ವಂತ ಹೆಸರಿನಲ್ಲಿ ಅಥವಾ 30 ವರ್ಷಗಳ ಲೀಸ್ ಅವಧಿಗೆ. Then my lord, that is the provision which says my lord, for starting new school this requirement is needed. But my lord, in my case I have been running classes 1 to 8 since for several years. Now I am also running.
Go to the next. ಮುಂದುವರೆದು.
Next paragraph.
ಮುಂದುವರೆದು.
ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 1ರ ಅಧಿಸೂಚನೆಯಲ್ಲಿ 2017-18ನೇ ಸಾಲಿನವರೆಗೆ ನೋಂದಣಿ ಪಡೆದು ನಡೆಸುತ್ತಿರುವ ಶಾಲೆಗಳಿಗೆ ಮೇಲೆ ತಿಳಿಸಲಾದ ನಿವೇಶನದ ಅಳತೆ ಅನ್ವಯಿಸುವುದಿಲ್ಲ. Clearly says, my lord, this will not apply to the existing schools. To start higher classes from 9 to 10 or whatever.
My lords, may I?
Last paragraph.
Yes.
Now.
My lords, may I point to annexure M at page 39, my lords, which is a representation by the petitioners themselves. Point number 10, my lords.
No, correct, but whether this,
No, my lords, so
these conditions for fresh are applicable to upgradation.
that is the question, my lords. If your lordship sees point 10, my lords, this is a representation, page 39, annexure M. ಸದರಿ ವಿದ್ಯಾರ್ಥಿಗೆ 9 ಮತ್ತು 10ನೇ ತರಗತಿಯ ಶಿಕ್ಷಣವನ್ನು ಮುಂದುವರೆಸುವ ಪ್ರಯುಕ್ತ 2019-20 ವರ್ಷದಲ್ಲಿ ಶೈಕ್ಷಣಿಕ ಅವಧಿಯ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ತಿಳಿಸಿರುವ ಸದರಿ ಮಾನ್ಯತೆಯು ಇಲಾಖೆಯಿಂದ ತಡವಾಗಿ ತಲುಪಿದ ಕಾರಣ 9 ಮತ್ತು 10ನೇ ತರಗತಿ ವಿದ್ಯಾರ್ಥಿಗಳನ್ನು ಸದರಿ ಸಂಸ್ಥೆಯಲ್ಲಿ ಉಳಿಸಿಕೊಳ್ಳಲು ಸಾಧ್ಯವಾಗಿರಲಿಲ್ಲ. ಆದುದರಿಂದ ಉಲ್ಲೇಖದಲ್ಲಿ ತಿಳಿಸಿದ ಮಂಜೂರಾತಿ ರದ್ದಾಗಿರುತ್ತದೆ. Now, my lords, the question would now be whether the permission sought by them would be for fresh institution, recognition or continuation, my lords.
So upgradation.
It would not be upgradation in view of this. Raddagiruttade.
No, that is what they are saying.
Yes, my lords.
That is there what they are saying.
Yes.
But what is the position now? Now they're seeking for upgradation. Now whether the conditions applicable for a new institution is to be done only also.
Yes, my lords. Admittedly, it had stopped operating classes for 9 and 10.
No, that is there, but
Yes.
if there's whether upgradation also requires that which is required for fresh or no.
From the reading of the circular as well as the rules, it would appear that upgradation would not require it. I will secure instructions, my lord.
Let us.
Blood, who I have sought for an interim order also. Blood, they are insisting that, my lord, I have to close the classes 9 and 10. My lord, students are already studying there.
No, correct. We now will consider it on a prima facie consideration, subject to the condition that you will not claim equity in the event final order is passed. The Learned Counsel appearing for the petitioners submits that the petitioner is seeking for upgradation in terms of amendment to Rule 3 of the Karnataka Educational Institutions, Classification, Regulation and Prescription of Curricula, etc. Rules 1995. Full stop. It is submitted that they're already running a school from classes
1 to 8.
1 to 8. Yes. Full stop. It is submitted that by virtue of the circular dated 7/10/2023, the respondents are seeking to impose condition as applicable for starting new institutions for the petitioner who is merely seeking for upgradation. Full stop. In light of the contention raised, there would be an interim order restraining respondents from
Disturbing the Millard classes. I am not, I am insisted, Millard, not to continue with classes 9 and 10.
My lords, with
no, but upgradation, no order is passed still.
my lords, with permission.
The procedure is, Millard, during the start of the academic year itself, Millard. the
Just 1 minute. We'll have it at
Management.
2:30, just.
Mallods,
2:30, mentioning at 2:30.
serial number 70, Mallods, was urgent. If your lordships could take it up anytime.
Lordship, serial number 91 and 97, your lordship.
ಇಲ್ಲ ಎಷ್ಟೊಂದು ಇದೆ
My lord's kind permission, I make a submission. My lord, serial number 59 is listed before my lord for compliance of office objection. I will comply them, my lord. Matter may be listed on 16th, please, my lord.
59, relist the matter in the same, the fresh matter.
Please, my.
And the fresh matters list on
16th, my lord, please.
16. Office objections to be complied by them.
Please, my lord. Much obliged.
Lordship, may I make a mention of serial number 91, your lordship?
Yes.
Serial 91, your lordship, is a covered matter, lack of opportunity before passing the assessment order.
Let us see, just wait.
Lordship, can it be on next week, your lordship, under the caption order, your lordship?
91.
16th on caption order.
Relist the matter in the orders list.
Even serial number 97, your lordship.
Just 1 minute. Matters that are required to be disposed of will come only in the preliminary hearing list.
Even serial number 97, your lordship.
No, Bree group and all.
That's a fresh matter, your lordship.
Let us see. Huh?
My senior is arguing in this matter, your lordship. He'll be appearing, lordship, the stay to be granted, your lordship.
Then let it come in orders list. That's all.
Ordered
91
list.
in preliminary hearing list. 97 in orders list.
24.
On 16th, your lordship.
Yes.
My lord, serial number 70.
Much obliged.
Yes.
There was an urgency, my lords. Exams are starting from Monday. The lordships could
Serial
assign
number?
me some time during the day, my lords.
Serial number
70, my lords.
70. Who is the other side?
So they're here, my lords. NCIS and council, my lords.
I appear for NCISM.
Then
Small matter, my lords.
R1.
Yes, my lords.
You appear for R1.
Yes, my lords. R1, my lords. 70.
Where is Girish? Girish is there.
I have informed. Yes, my lords. Learned Council's colleague is here, my lords.
I appear for R2, my lord.
You are seeking for interim order.
Prior to appear in the exams, my lords, there is no
The answering respondent.
NCIS, my lords. Krishna.
My lords, I appear for R1.
When is the exams?
Monday, my lords. This institution, my lords, had approached this honorable court for increase in intake capacity from 45 to 60, my lords. Pursuant to interim directions, my lords, for the academic year 2020-21 and 21-22. admissions were made for the increased intake capacity of 15 students, my lords. Eventually, my lords, this honorable court has allowed the writ petition. It is at Annexure D. In Annexure D, ink page 31 is the order, my lords, passed 4th March 2024. Directions are at ink page 39, my lords. My lords, in the earlier round of writ petition, honorable court had permitted the students to continue and appear in the examinations. Writ petition is allowed, directing the NCISM to grant permission, my lords, to be issued. Because the requirements for 45 and 60, my lords, intake capacity is identical. University NCISM had granted permission for 45. Only that on short question.
My lords, I have few submissions to make. Kindly turn to page 39 of the writ petition. In that order 3, a mandamus is issued directing respondent number 2 to accord/grant permission for increased intake from 45 seats to 60 seats for the academic year 2021 and 21 to 22 within a period of 30 days from the date of receipt of the copy of this order. So in compliance of this order, the NCISM had issued a letter to the petitioner college. It is at page 46, Annexure H.
Yes.
Paragraph number 2, may I be permitted to read? Further, as per the order of this Honorable High Court of Karnataka, in its final order in WP 540 of 2021, to grant permission for increase of intake from 45 to 60 seats in existing UG BMS course for the academic year 2021, and as per NCISM Act 2020 and Subregulation 63I of establishment of new medical college, opening of new or higher course of study.
Just 1 minute. They have not paid.
They have not paid the security deposit of 25 lakhs for a period of 5 years.
That is the only condition.
That's the only condition in order for them to increase the intake for seats from 45 to 60. So
Which we undertake to pay, my lords, because it was only issued on 24/6. My lords, it was belatedly after repeatedly asking the my lords authorities for issue of formal orders.
Now, if that
We are undertaking to pay that. Yes.
If that amount is paid, the mandamus direction will be complied.
Yes, my lords. If the amount is paid, the security amount is paid, then we are ready to issue the formal order for permission of increased intake from 45 to 60 seats.
So conditional order will pass.
Yes, Your Honor. A condition order might be passed, subject that the matter is pending, and also a condition that they undertake to make the payment within a time fixed by this honorable court.
Now, what is the interim relief?
My lords, examination starting from Monday. Those students, my lords, earlier examination results are withheld by the university. They have to announce those results and permit them to take up the consequent exam.
That is the main relief.
Interim prayer, my lords. Interim prayer.
What is the main prayer?
Approve their admissions, my lords. In fact, my lords, it has already been allowed.
It is passed, there ends the matter.
Yes.
That is only based
That's all,
on
lords.
if they make the payment of security deposit.
Why 25 lakhs?
Security deposit, it seems, my lords, which we are willing to pay.
Just 1 minute, just. I'm saying what 25 lakhs for the petitioner, what is this? 25 lakhs in 1 hour you can pay.
My lords, that is, we have no difficulty, my lords, in payment. It was withheld by, in fact, my lords, the order for issuance of formal order is independent of this condition.
Yes,
It is not dependent on that, my lords.
How much time will you?
No, it's 2 weeks' time.
The petitioner has filed the present petition seeking for a direction to the respondent university to approve the admissions made by the petitioner institution to the increased intake capacity from 45 to 60 BAMS seats with respect to the academic year 20-21 and 21-22. It is noticed that the coordinate bench of this court in WP 5490/2021 disposed of the writ petition filed by the petitioner herein, directing the Central Council of Indian Medicine to grant permission for increase of intake from 45 seats to 60 seats for the years referred to above. Full stop. Such direction was required to be passed within 30 days. Such direction was required to be complied within a period of 30 days. Full stop. Orders passed on 4th March 2024 and till date, and as the order was passed on 4th March 2024, the institution has filed the present writ petition. Full stop. Third counsel so and so appearing on behalf of the respondent number 1 submits that the direction in WP 5490/2021 would be complied with subject to the petitioner paying an amount of rupees 25 lakhs as referred to at annexure H. Full stop. It is submitted that if a remittance is made, the orders would be passed within a period of
It will be passed immediately within a period of 2 weeks, Your Honor.
within a period of 2 weeks thereafter.
Yes, ma'am.
Accordingly, a case is made out to consider the request of the petitioner institution seeking for an interim order permitting the students to attend the appear for the UG-BAMS examination scheduled to be conducted from 15/7/2024. Accordingly, there will be an interim order permitting, permitting the students admitted to the petitioners as regards those admitted above 45 till 60 students, 45 to 60.
Yes, my lords. For the academic year 2020-21 and 21-22.
Who are admitted for the academic year 2020-21 and 2021-22 to appear for the respective subjects of UG-BAMS examination of July 2024, scheduled to be conducted from 15/7/2024.
Because they have to announce the results of the exams already undertaken and then permit them to appear, my lords, for the consequent examinations.
Needless to state, the submission that earlier results, needless to state that the submission of learned counsel appearing for the petitioner, that results of the examination earlier taken are also required to be announced in light of the direction passed in WP 5490/2021 requires acceptance. Accordingly, the second respondent
Yes, my lords.
is to announce the results.
Yes, my lords.
Of the
Examinations already undertaken.
examinations already taken up by the petitioner, students of the petitioner institution.
Great.
My lords, a date may be granted after 2 weeks for them to confirm the payment of security deposit.
Payment of 25 lakhs is to be made within a period of 2 weeks from today.
Yes, my lords. A date may be listed before this honorable court also. After 2 weeks.
So I pray for hand delivery, my lords.
Yes.
Great, my lords.
Grateful.
Lords.
Because 104 must have kept it for orders last week. They're ready with the matter.
Just wait.
104.
That could, I have other parted matter also. I'm not sure. Let me see at the end. After 4, I'll let you know. Otherwise, I'll refix a date. Let us see. because there's another further hearing matter, which 3/4 we have heard. Let us see. 4 o'clock, I'll let you know.
My lords, may I mention serial number 54? It's probably not likely to reach, lords, issue pertains to rejection of my appeal by the first respondent because I had not paid the pre-deposit, and on the previous occasion, my learned friend was to get instructions from the commissioner.
That I pay for the respondent. Their contention is that pre-deposit they have not paid. 54. The amount they already deposited, that may be considered as a pre-deposit. Sought instructions are not yet received the instructions. You may have it next week or week after next.
Lords, in the meantime, interim order may be passed to not take precipitative steps because we have reversed the amount as argued. We have reversed the entire amount since they had time to get instructions. An interim order.
They have
lords,
reversed the amount as per the directions of the respondent authority. Now they are saying that once I have reversed the amount, that itself can be considered as a pre-deposit.
The entire amount has been reversed.
I have sought instructions.
Let us see, but don't reject the appeal.
No,
They have passed an order rejecting mine.
because already order has been passed.
So we say don't take precipitative.
Precipitative steps until next date of
The
it.
respondent is not to take precipitative steps till the next date. Relist the matter on
Around 2 weeks.
30th.
yes.
31st.
Much obliged.
Serial number 3, Anusha Reddy.
I appear for the petitioner, my lords. Petitioner is a practicing advocate, my lord. And she has received a notice from the respondent to pay service tax, my lords. I'm filing a memo,
No other income.
no other income.
The petitioner as a practicing advocate and has sought for called in question the order submits that the identical question has been considered by this court.
In 8414 of 22.
Harsha Desai, that court, same order. Harsha Desai. That same order which are passed. Same order.
At least 2 serial number 14 also arises out of the same, this 26 years. List 2 serial number 14. There also, my lord, it is arising out of 26 years order.
When it's called, we'll take it up.
Yes.
ಇದು ರೆಫರ್ ಮಾಡಿ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿ ಸೇಮ್ ಆಸ್ ಚೇಂಜ್ ಇದೆ.
And my lord, if it is found that if there is any other income, my lord, department will be given the liberty.
Yes, yes.
That will be recorded. If on investigation, if it is found, if there is any other income.
No other income.
Filed a memo, my lord, but if we find it from our intelligence that if there is some other income.
So memo filed, which is taken on record. Memo filed to the effect that the petitioner has no other income is taken on record and noted. Needless to state, if it is found that the petitioner has any other income, it's always open for the authorities to take appropriate action.
I'm good.
List 2, order serial number 1, Sandeep.
The matter was in the midst before lunch.
Just
Serial number
30.
Yes, ma'am. Yes, ma'am.
No, now you have
30.
You have filed your application, is it, for upgradation?
Yes.
Now that no order is yet passed.
No.
But then some
My
order
lord,
must
they
be.
only say, my lord, I have to obtain this certificate.
No, my lord.
Conversion of land for educational purposes. My lord, I have applied, it is pending, my lord, before the appropriate authority.
I am expecting the order within 1 or 2 months.
My lords, if I may.
You're correct, but then how we can give interim?
My lord, let them not precipitate, my lord. Just limited relief.
My lords, if I may submit, what is being submitted is an application for recognition, my lords. Now, if upgradation were to, no.
Upgradation.
Upgradation is a separate application, my lords. Now, recognition is what has been denied to them. That
Okay,
is
yes.
subject to their application for upgradation. Your lordship may
No,
see
now-
annexure K.
Just one, 1
Yes,
to
ma'am.
8, they're already running.
Yes.
Yes,
Now, they've sought for 9 to 10.
yes, my lord.
Though it may be an application for recognition of 9 to 10, in terms of that circular, it is to be treated only as
Yes.
for upgradation.
Yes.
On that, you will have to now decide.
My lords,
The insistence on conversion is what they're saying they're aggrieved by. Otherwise, whatever the other conditions for upgradation, they would follow is what they're saying.
my lords, subject to correction, if I may read out annexure K, the bottom 5 lines, my lords. ಉಲ್ಲೇಖ 2ರ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋ ಯಾವುದೇ ಶಾಲೆಯಲ್ಲಿ 1ರಿಂದ 8ನೇ ತರಗತಿ ಅಥವಾ
You're reading?
annexure K, my lords, at page 29,
Yes.
last part of the page. The last 5 lines, my lords, the last para. ತರಗತಿ ನಡೆಯುತ್ತಿದ್ದು ಮತ್ತು 9 ಮತ್ತು 10ನೇ ತರಗತಿಗಳನ್ನು ಪ್ರಾರಂಭಿಸಲು ಬಯಸಲಿದ್ದ 9 ಮತ್ತು 10ನೇ ತರಗತಿಗಳು ನೋಂದಣಿ ಮತ್ತು ಮಾನ್ಯತೆ ಉದ್ದೇಶಕ್ಕಾಗಿ ಉನ್ನತೀಕರಣ. So for the purpose of recognition, and I'm not sure if the application filed by the petitioner is for recognition or upgradation, my lords, because recognition is subject to upgradation. If the application is filed for upgradation, I'll have to ascertain whether any orders are passed on that.
You find out.
Yes, my
But
lords.
the rule says, my lord, if I file an application for recognition of
Is to be
higher
treated as-
classes,
it is to
it
be
has to be
treated as-
treated
My
as
lords,
upgradation.
only on that aspect, my lords, I'll need to secure
Find
that.
out, find out. We'll only say, don't take any precipitative steps.
Very well.
And then let us.
Very well.
But now you have to comply with the other requirements. For
My lord, all
upgradation.
the requirements are complied. Only because of this, the matter is pending.
You have counsel for the petitioner. In light of the contention raised, there would be an interim order. There would be a direction for the respondents not to take any precipitative action against the institution insofar as the subject matter of the, insofar as students of class 9 and 10 are concerned till the next date. Release the matter week after
Next week. Oh, very well, my lords.
Date good. I'll in the continuum. Yes.
List 2, orders, serial number 1,
Date.
Sandeep.
You put it there, yeah. So now, these matters fall within that batch.
Please, ma'am, please.
Huh?
Please, please.
Okay. So now, serial number 1. Now in that form, you just fill up whether it is a challenge to show cause notice, orders in original, orders in appeal.
One is order in original.
Orders in original.
Yes, it's only one impugned order, annexure A.
This one could be form. You just pick it and then give it to the next petition.
In this case, subsequent to the order in
So
original.
just 1 minute. So first you just make an entry. So it will be orders in original, please, isn't it?
Yes.
Yes. Elected microphone.
Office objection. What is office objection?
Lords, this was with respect to one of the documents was unclear. At that time, I had made a submission saying we won't be
Office
relying.
objection is waived. So now, in terms of that order, since it's order in original, it will go back.
Please.
Isn't it?
There is a subsequent bank attachment to annexure B that may also kindly be set aside.
in light of serial number 1 in WP 23317 of 2023, as it is submitted that there is an order of bank attachment consequent to the past order in original. In light of the matter being relegated for fresh consideration, the order of bank attachment stands is set aside.
Connected matters. M. Kumar. M. Kumar.
Lord, in this matter also, it's an order in original.
Order in original.
IA 1 of 23 is allowed and petitioner dispensed production of certified copy of annexure A. Order in original is set aside and matter is relegated. So in that, make an entry in that list.
I have done. I mentioned the WP number.
Yes.
Serial number 2, Shiva Yogeshwar.
Annexure B, order in original. Right. Annexure B, order in original.
Order in original.
Yes, madam.
Just make an entry in the list.
Yes, madam, I will read. That I have given the list also, madam.
Order in original is set aside.
I will read it.
Matter is relegated.
Connected matters.
2.1 also, madam, order in original.
6765.
2.1.
2.1 is also order in original. Order in original. Yes, madam.
Order in original 2.1
Serial number 4 also, madam, order in original.
is set aside.
Serial number 4.
Serial number 4, madam.
Serial number
G1 nearly.
5 also, madam.
just 1 minute, just 1 minute.
Order in original.
Just wait.
Serial number 3. Annamalai.
The petitioner challenged both so-called notice and order in original, my lord.
So that is
Order
the
in original may be set aside. We will send it back at the stage of so-called notice.
order in original is set
To
aside.
file reply, same order.
Yes.
My lord, 3, my lord, I appear. Vanita Kyar's name may kindly be deleted.
Office to show the name of Land Council G1 Jain for the respondent. To delete the name of Land Council Vanita Kyar. Yes.
Serial number 4, Shiva Yogeshwar.
Serial number 4 in order in original.
Serial number 4.
Order in original.
Order in original. Please make an entry in the list.
Annexure.
Serial number 5.
5 also order in original, madam.
Order in original. Preeta appears for
No, my lord, she is not appearing. My name may kindly be shown.
Land Council G1 accepts notice for the respondents.
Yes.
5.1 is also
Office
order in
to-
original.
Just 1 minute. 5. Office to delete the name of Land Council Preeta M.
5.1.
5.1 is also order in original.
5.1 I appear, but it is order in original.
5.1 order in original.
Yes.
5.2.
5.2 is
Just
also
1
order in
minute.
original.
Just 1 minute. Preeta M.
Fine.
Sorry.
Illa.
Office to delete the name of Land Council Preeta M. Yes. 5.2.
5.2 is also order in original.
I appear in that.
So then G1's name must be deleted. 5. Office to delete the name of Land Council G1. Order in original.
Yes.
Yes.
6. Annamalai, yes.
In this matter also, order in original has to be set aside.
Order in original.
Order in original. IA 1 of 24. IA is allowed. Petitioners dispense the production of original copy of A and B.
I appear.
Yes. 6. Land Council Arvind C. Chauhan is directed to accept notice for the respondent. Office to delete the name of Land Council G1. This is 7.
Seven.
Sorry, 1 ನಿಮಿಷ.
3, 5,
6 ಅಲ್ಲಿ
6.
6 ಅಲ್ಲಿ ಆರ್ಡರ್ ಇನ್ ಒರಿಜಿನಲ್ ಡಿಸ್ಪೆನ್ಸ್ ಆಫೀಸ್ ಟು ಡಿಲೀಟ್ ದ ನೇಮ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಕೌನ್ಸಿಲ್ G1J ನೀರಲ್ಗಿ ಅರುಣ್ ಚೌಹಾಣ್ ಹೆಸರಿದೆ.
7.
7.
7 to 11.
ಹಾ.
Just make any dealing, my lord. There are some other issues are there. Submission, my lord. Please see page number 157 for a moment, my lord.
I'll come back, just wait, I'll come back, I'll come. Yes.
8,
Hello.
7 to 11, my lord,
11
there
bit.
one.
7 to 11 bits.
serial number 12,
There are some other issues are there.
Let us see, just
Please, my lord,
12,
not
Shiva Swami.
12,
12.
12, 12.
12 also, my lord, appeal, my lord. Appeal stage, my lord. Assessment order is
As on today, the tribunal is not functioning.
So the appellate order and
Appellate order
order
has to
in
be set
original are
aside.
set aside.
Appellate order has to be set aside.
Order in original has to be set aside.
Then
Matters remitted
matter
to.
remitted to
remand.
Appellate order is set aside. Order in original is set aside. Matters remitted to the stage of reply to show cause notice, to the stage of post show cause notice.
Serial number 13 also order in original.
13,
13. Order in original.
Order in original.
My name may be shown and Vanita Kya's name may kindly be written.
And matters remanded,
13.
office to delete the name of land counsel Vanita Kyar and to show the name of land counsel Jeevan J. Neeral.
14, serial number 14. Kamath, Amit Deshpande.
What is this?
I take
Lordship,
notice.
may we permitted to make a mention in respect of serial number 71, your lordship?
No, just wait, just.
Okay.
14,
But I may permit you to go through the file.
Just-
ಅವ್ರು ಇದಾರೆ ನೋಡಿ, ಅವ್ರು ಇರ್ತಾರೆ ಒಂದ್ ಸತಿ.
Amit. ಆಗ್ಲೇ ಮಾಡಿದ್ರು.
This also may order in original.
Serial number 14. Order in original is
Original, annexure A.
set aside. Yes. Yes, now. So 7 to 11.
But someone, please, 14, my name may be shown, Malanda. His name may be.
In 14, office to show the name of land counsel Jeevan J. Neeral and delete the name of land counsel Amit Anand Deshpande.
Lord, please see page number 157 of the writ petition, Malanda.
Serial number 7.
Now the others in the first list, some of them are still to give the numbers.
102 in place, policy not before not in income tax after
No, just one, I'm saying the other list of similar matters, service, the petitioners have still not given the.
Lordship, 71 is one of such kind matter, one of such matter, your lordship.
71.
71, your lordship.
Just one, 71 and same service tax.
Same service tax from your lordship.
71.
This is the fresh matter, your lordship. I served copies on Mr. Jeevan, your lordship.
7.
Just one. Just one.
71.
71.
That also has to come in this batch.
This batch, your lordships.
PWD contract.
Exempted service and PWD contract. Even what contract says that more range.
Income tax.
Period. The finance sector. Agreement entered in
71.
March 15.
This is income tax.
71, your lordships.
Huh.
Informing clear
Again,
period.
it is being fetched from 26.
Okay.
18106.
Okay. Huh. Now this is order in original. is it?
We have challenged both order in original as well as show cause.
Demand it back. Original.
71
They are
notice.
saying
Yes, Jeevan.
Please. Yes, my lord, order in original,
Yes.
It can be set aside.
annexure.
Annexure C.
Huh. Order in original is set aside, matters relegated. Office objections?
Office objections, there's only one objection, your lordships. What happened was in ST3 which we filed, the copies were not legible and the font size was small, and we were asked to file the enlarged copies which.
Office objection is waived. Land Council Jeevan accepts notice for the respondents. One not? One not?
86, my lords.
Just 1 minute.
One zero two.
It's the OIO, the connection.
Connected matters.
Connection.
102 or 102.1?
102 is all DBMP matters.
No. 102.
just 1 minute. 102
Yes.
is order in original.
OIO.
My lord, 102, they have not sold the copy. 102.1, yours.
102, you just have a look. Huh?
Please.
Put it. 102.1 told.
02.
Yes. 102.1. Yes, Chidanand.
Order in original.
The OIO, order in original.
Order in original.
Order in original.
Original.
Order in original is set aside, matters relegated.
ಎಷ್ಟು serial number item?
What about, what is the office objections?
102.1, my lord, I take notice in 102.1.
Office objection is waived. Office objection is waived.
Order in original.
Land Council Jeevan J. Niralgi accepts notice for the respondents. 102.
02, my lord, they have not served the copy, my lord, they have already. ಅಲ್ಲ, ನಿಂದ
ಕೊಟ್ಬಿಡು.
102.1 ಸರ್ದು. ವಿನಾಯಕ ಇನ್ಫ್ರಾಟೆಕ್. ಇದು ನಿಮ್ದು ಸರ್. I'll give it 1714.
This is also.
Order in original. Order in original.
Order in original, my lord.
102, order in original.
Yes.
Set aside.
86, my lord.
Same.
Same, order in original, my lord.
86.
86.
56.
Order in original.
Order in original. Annexure F, my lords. Serial number 31, my lord. Order in original, my lord.
Serial number 30.
31, my lord. 31, my lord, I thought this is. Yes. Annexure A, my lord, order in original.
Council G1 generally accepts notice for the respondent. Order in original.
Order in
Yes,
original.
order in
Annexure H, show cause notice is issued on the basis of income tax return.
You continue, madam. Continue, madam. The previous batch which we disposed of, still some of the lawyers has to give that form.
Two and two
Yes, my
numbers.
lord, I have,
together.
I have circulated it, my lord.
Yes, yes. Some of them are still to give.
47, your lord. Serial number 47, order in appeal.
47.
My lord, order
47.
47. Lordship may have it on 16th in orders list. I'll just verify because order in appeal, there is a detailed order. So I'll just go through it and just.
On
16th in orders list.
16th in orders.
In case of income tax.
Show cause notice, annexure.
The number 79.
Yes, sir, you note income tax department.
79, sir. Please. 79.
79.
79. Order in original.
Order in original.
Form 26 years.
You can cross check.
26 years, show cause notice.
You can cross check.
Please.
79 order in original. Office objections are waived. Yes.
Form 26 years, show cause notice.
7 to 11, yes, Jeevan.
My lord, 7 to 11, my lord, there are some other issues, my lord. This is not the only this thing. It is a
On
government
this issue,
company.
it can go back, my lord. I'll make my submissions, my lord. One matter may same common order in original for all 5 cases, my lord. The first matter may be taken up, my lord. 2 minutes I will, point it out, my lord, where they are relied upon, my lord. The income tax.
I just need to go through once again, my lord.
Yes,
Lord may have next Tuesday or whatever.
7 to 11. This is the
Lord
matter.
may have.
In the fresh matters list on 16.
Please, please.
And that day, any other people want to join, they can join.
The interim order may be extended.
Interim order earlier grant is extended till the
1 to
next,
11, my lord.
next day.
My lord, today's fresh list item 13, my lord, which came up.
Just 1 minute. List 2 13. Okay.
Serial number.
For that night.
Pass over matters. Serial number 2.
Just 1 minute. Now your matter is also covered in the same batch.
Yes, my lord. It is based on income tax return. It is order in original, my lord.
Serial number
13.
Serial number 13, today's fresh list.
Just 1 minute. No,
Serial number 13.
Order in original.
Serial number 13, isn't it?
Yes, yes.
Yes, my.
Annexure 8, page number 37.
Order in original,
Yes.
same order.
Serial number 13.
Much of it.
Pass over matters. Serial number 2.
I refer for the petitioner. This is a matter where 148 proceedings have been taken.
Income tax, yes, income tax.
Income tax. The assessment order has been passed. He passed away. The person filed writ petition number 9725, challenging the order passed under 148D and also 148. The matter was heard and reply also been filed by the respondent. In that set time, he passed away on 8/11/22. The writ petition was withdrawn. Thereafter, the first respondent initiated proceedings and she passed an order against the dead person and also the PAN and issued a demand notice. This is a matter where 3 years time limit has been over. Under the capital gain tax, which has been declared as 4,33,000.
No,
But
you examine. When
I
shall
will
you-
examine Tuesday, my lord.
Release the matter in the orders list. You may have to file your objection.
Your lordship, I will just see whether the death was before the initiation or after the initiation, my lord. Either way, my lord, it is a 2016 assessment, 2016-17, and notices are dated after the Ashish Agarwal, my lord. Your lordship, if the initiation is after the death, my lord, it may not continue, my lord.
It's after death only. You may have to take your.
I will
time.
just I will just examine, my lord, what it is. I will receive the copy.
Release the matter in the orders list. Land Council Sanmati accepts notice for the respondent on
23rd.
Yes.
Number 23, Srihari, 23.
Senior is in another court. There is some urgency in this matter, my lords. Lordship may have it tomorrow, my lords. Possible because they have made recovery before due date for filing an appeal.
16.
16.
Lordship, if possible tomorrow, my lords, we'll take a chance.
I have other roster. Yes.
Under the same stage, my lords.
Yes, same stage. Same stage.
Oblige.
32, Ravi Raghavan.
Please.
You continue. Yes.
My respondents, 2 will be the state, my lords. 1, 3, 4 is center.
Council. Union of India.
Global Green.
I take notice. If the central tax.
Even accepts notice for
3 and 4 also minutes.
respondent 1, 3 and 4. State. Shaman
State,
Naik
my lords.
for R2. Yes.
My lords, the issue in this case is, my lord, they are challenging a notice where they are proposing to recover refund of unutilized GST credit, which they have sanctioned to us because I have exported goods. I have claimed refund under Rule 89(4) of the CGST rules. The case of the department is, my lords, that I am importing certain goods in which I am claiming exemption under notification 78 of 2017 customs. Therefore, I should have ideally claimed refund under Rule 89(4)(b). The refund under 89(4) my lords, was sanctioned after due scrutiny, verification of all the documentation. There is no, it's an option, my lords, either 89(4) or 4B. They cannot force 4B into me, my lords, and reject or recover the refund which has already been sanctioned to me. In fact, my lord, during the process of the investigation, I had pointed out that I have claimed under 89(4). If according to them, I should have claimed under 89(4)(b), my refund amount would have been much more than what they have sanctioned to me by way of speaking orders. And therefore, my lord, despite that, they have issued a notice. And similar matter, my lord, have considered and granted interim of order, my lord.
ಇದು ಬೇರೆದು.
Prayer.
This element 4 is a different issue.
Same 89(4)(4)(b).
Just wait 5 minutes.
And refund, my lord, in my case, I have. Interim order.
Here is a
The issue
prayer.
in this case was that where there is a challenge to the provisions of Rule 89(4)(b).
There's no interim order.
There is no precipitate action in that, my lords, in the first.
No,
18
ಇದನ್ನು
minutes.
bearing grant and so and so and so. And corrigium to show cause notice, those steps relating to the person to grant such, so the advocate filed an application, so response to the production. Advocate filed an application section.
Well, the otherwise, in this case, the issue, Manoj, I'll point out, I am exporting goods.
No, there is no.
Let us see anyhow.
Well, I'll just go through, that's, yes, I'll just, whether there is any similarity in this two matters.
We'll have it on
This-
Tuesday.
Please.
Please release the matter in the orders list on Tuesday. Learned Council.
Element for that.
Even accepts notice for respondent 1,
Lala.
3 and 4. Chamant Naik, point number 2.
33.
A1 of 24 is allowed. Petitioners dispense with production of certified copy of annexure A. Yes.
Well, interim order, let's stay of annexure A.
They said they'll check.
I
Tuesday.
just, Tuesday.
Tuesday. Yes.
33.
That's in
The
the-
copy code, Ravi. Ravi, copy.
This matter, my lord,
Give me copy.
that's what we are seeking is for no course steps in terms of annexure B. The issue here is that, my lords,
Central Board of Indirect Taxes.
that would come under the copy
State
has been
Commissioner
served.
of Commercial Taxes.
3 and 4, I'll take notice.
Learned Council Chamant Naik accepts notice for respondent 3 and 4.
1 and 2, Mr. Jivan will take.
1 and 2 Learned Council Jeevan. Niralgi accepts notice. Yes, what is the matter?
That's what the matter is that, my lords, last year in the month of October, there was an rule which was introduced, my lords, Rule 28(2), whereby, my lords, corporate guarantees which have been given by a company to a connected company has been.
This is the same one. Same one.
Yes.
Which is that? Which is that matter? I think Mr. Shivdas appeared, isn't it?
Shivdas appeared.
That I-
One Shivdas appeared and one Raghuraman appeared. There are two
Just-
matters, I just.
That's
Before that, you give that interim order.
That I was relying upon.
No, then no. Give this.
This
one.
court has passed an interim.
Yes, yes, I was getting the
Ah.
interim.
Morning also, my lord, today morning, my lord, one Mr. Aditya appeared, I believe, the list.
That's then I'll take that itself.
ಅವ್ರನ್ನ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ನನಗೆ, ಕಾಪಿ ಕೊಟ್ಟರೆ ಗೊತ್ತಾಗ್ಬಿಡೋದು.
Anirudh.
Anirudh.
Serial number 17, my lord.
Serial number
17.
17. Corporate guarantee. And that. Corporate guarantee, same as in 17.
17. I'll verify that, my lord. but
Hmm,
usually
check
it's-
madam.
Annexures.
Corporate guarantee. And that. You have to work hard.
That's I got
No,
it from the.
Correct, what I'm saying, to maintain consistency, if you can get the same.
No, I will find out. It's by 4:30. I'll place it. So, yeah, repeat.
IA 1 of 24.
34.
IA 1 of
Passed
24
over,
is allowed,
sir.
and IA 1 of 24 is allowed, and
Passed over.
petitioners dispense with production of annexure A1, A3 and D. I passed the same interim order, just see if you can get it.
I'll get that.
Yes, yes.
34.
Lord, my lord, the petitioner challenged a assessment order along with the 148 AB notice, all the thing, my lord. So far as 148 AB notice is concerned, my lord, please see page number 73, my lord. The notice is dated 22/3/2022, my lord.
22/3/2022.
22, my lord, and directing to file reply by 25/3/2022, my lord. Only 3 days time has been given, my lord. As per provisions of 148 AB, minimum 7 days requirement is there, my lord. Consequently, the notice itself is invalid in my law, my lord. I am relying upon this honorable court decision, my lord, wherein the honorable court has set aside all the notices along with the assessment orders. Same order may be considered.
No, but now assessment order also is passed. is
Yes,
it?
my lord, assessment order is also passed, my lord. The identical issue is there in that matter also, my lord. Assessment order is also passed, my lord. Para number 5, my lord.
Assessment order is passed when?
Assessment order is passed on at page number 62, my lord. February 2024, my lord.
Ex-parte, is it?
Yes, my lord, all ex-parte order. In this order also, my lord, in this judgment also, my lord, the assessment order is also impugned, my lord. At para number 5, my lord.
Yes.
Well, it's already more than 2 years over. Let him take another 2 weeks' time.
To the stage of 148 AB.
No, no, my lord. This 148 AB can question, my lord. The same order like liberty may be provided to them, my lord. If at all they require, they can issue fresh notice, my lord. The same order may be.
No, is time available?
Yes, my lord, yes, my lord.
Time is available.
Yes, my lord.
Time is, no, that is subject to obtaining permissions from.
No, correct. Now, suppose you were to issue 148 AB.
AB,
Yes,
time
yes,
is available, my lord. Time is there, my lord.
Then we'll reserve liberty.
Okay. Yes, ma'am.
If time is not available, then we will not pass any observation. But where time is available, we'll make it clear. The petitioner called in question the correctness of the assessment order at annexure A1, as well as the demand notice at annexure A3 and the penalty notice at annexure A4 and A5. In the case of the petitioner, that the 148 AB notice at annexure
Annexure B1, my lord.
annexure
B1, my lord. B1, my lord.
at annexure B1 was issued on 22/3/2022, requiring compliance by 25/3/2022. It is submitted that the time limit afforded was contrary to the mandate of 148 capital A small b. Other contentions are also raised that the said notice is not signed. So,
No, my lord, that not served, my lord, not served, my lord.
better, not signed by us. It is contended that in light of the short time made out for reply.
So if they say that it is not served, we have to verify the facts. Because in similar one instance, they have an order has been passed saying that it is not served, and later on he produces, the officers produces the acknowledgement.
I'll have it on Tuesday.
So if they only 7 days time, that's okay, my lords. And then what happens is they will come back to us saying that here is the postal acknowledgement.
So only on the 7 days I'll set.
Only on 7 days it may go, my lord.
Then we'll end up filing a review petition.
No, my lord, only on 7 days it may be disposed.
As the petitioner was prejudiced, he was unable to participate in the proceedings, which has resulted in passing of an assessment order under best judgment assessment.
Please.
It is submitted that the petitioner has a good case on merits, and if an opportunity is afforded, petitioner would be in a position to demonstrate that no 148A(D) order is required to be passed. Taking note of the time for response being in violation of the statutory mandate under section 148 capital A small b, which requires time of not less than 7 days to be afforded, and also noticing that the assessment proceedings are concluded without participation of the petitioner. It would serve ends of justice by relegating the matter back to the stage of, it would serve the ends of justice by setting aside the proceedings while reserving liberty to the revenue to take appropriate action insofar as the subject matter of the notice under section 148, capital A, small b, as is permissible under law. All contentions are kept open. Accordingly, the orders at
A1 to A5 and B1 to B3, my lord.
A1 to A5 and B1 to B3 are set aside. All contentions are kept open. And Council Thirumalai accepts notice for the respondents. IA1 of 24 is allowed. Petitioners dispensed with production of documents at annexure A1, A5, A1 to A5 and B1 to B3. Yes.
Much obliged.
Please.
Yes.
The respondent is the state funds.
ಇದು ವರ್ಕ್ ಆಗ್ತಿಲ್ಲ ನೋಟ್ ಮಾಡಿ ವರ್ಕ್ ಆಗ್ತಿಲ್ಲ ಇದು ವರ್ಕ್ ಆಗ್ತಿಲ್ಲ. Yes.
Also, I undertake research and development of software relating to the metro rail, the traffics and other signaling management system. After I undertake the research and development, the software is uploaded on my repository. My group entities outside India use this software which I have developed and for various goods that they manufacture and they export to India. This is an R&D activity which I do for my group entities. I receive money in foreign consideration, in foreign exchange. And I am treating it as an export of service, claiming whatever attendant benefits are there under the GST law. The contention of the department, is that this activity of R&D, since I am doing it in India, even though the recipient is based outside India, it will be considered the place of supply will be in India. Therefore, I am required to pay IGST on this transaction, which otherwise is an export transaction. The show cause notice proposed to demand IGST on this R&D activity, which admittedly is actually an export of service which I undertake. Even though I undertake the R&D here, the benefit of the R&D, the reports, etc., is uploaded in my portal for use by various other Alstom entities outside India.
Just one. Who appears? All. Yes.
Therefore, our contention right through has been that it is an export of service. The place of supply is outside India because it is based on where the recipient is located. And the recipients are all outside India. Therefore, the contention of the department that section 13.3 will apply, 13.3A will apply is not correct. Despite our repeated submissions with authorities, this demand has been issued based on an audit objection. Similar issue came up for the earlier period along with other connected issues, on this holding of shares by the other entities, etc. This honorable court is seized of one of the matters, the earlier matter, where interim order has been granted, staying the adjudication of the show cause notice. In this case, the show cause proposes to demand its IGST on this transaction on the ground that the place of supply is in India only because I undertake activity of R&D in India. If that be the case, every other service, because it's undertaken in India, all software development, etc., the activity will be done in India only. The beneficiary is outside, the recipient is outside India. The place of supply in terms of the rules, should be in provisions should be where the recipient is located. The recipient here is the other Alstom entities located in France and other jurisdictions who use the R&D which I have undertaken of the software developed. They use it in the manufacture of various signaling equipments which they export to India for use by Metro.
Which is the interim order in the other matter?
It's the
Page 41.
Page 41 minutes. That was one of the issues in the matter before this honorable court. Though the honorable High Court records 2-3 issues, the other issues are covered in that show cause also. The substantial demand in those matters were relating to the holding of shares by the holding company and goodwill, including this issue, where there is an export of the R&D activity. I'll just hand over a copy of the show cause in that matter.
Anyhow, we'll not refer to that because it's not referred, but this matter requires some consideration. In light of the contention that the place of supply is outside India. Petitioner submits that the impugned show cause notice treating place of supply in India.
Yes, my lords. Merely because the R&D activity is undertaken in India.
As R&D activity is conducted in India is a matter that requires consideration. In the interregnum, there would be stay of further proceedings pursuant to the show cause notice at Annexure
A, my lords.
A. Non-consummate bank accepts notice for the respondents. IA 1 of 24 is allowed.
Obliged. Wait.
$37. Bharat, me?
The arguing counsel is not available at the moment. Can we pass over that?
It won't reach today. You'll have to take it up on Tuesday.
Okay, sir. The 37, 38 and 40.
37, 38 and 40. Relist the matter in the fresh matters list on 16.
Much of.
41. Anamala, yes.
39.
Silver. 39.
Arjuna, 41. Yes.
40. Serial number 40.
Hello, 46. 41.
46. 41.
These are the royalty matter, my lord, royalty on GST, my lord.
Same order. Page, order in other matters, page.
My lord, page show cause notice, my lord, page number 34, my lord.
Interim order is 100. 100. Seems to be a 100.
My lord, similar matter has been stated by 90 also. Honorable court, my lord. Similar interim order, giving copy of interim order, some other matter.
Petitioner submits that identical issue has been raised in other matters. And court has taken note of his order of the apex court and granted interim order. The question of tax on royalty is a matter still open for still matter of adjudication. Accordingly, subject to further consideration, there would be a interim stay of
Annexure A1 and A2, my lord.
Annexure A1 and A2 insofar as GST on royalty.
Yes, my lord. No, in this matter, only royalty
Same order
is
as
the
in
only issue, my lord.
27.
But the union is not there as a part.
Same order as in 27. Yes.
42. Ravi Raghavan.
Don't it can be the royalty. The same as on. Yes.
Your Lordship, respondent number 2 and 3 state, Lordship, for the same petitioner for the previous matters for 2017-18 and 18-19, the Honorable High Court has already passed interim orders.
Same.
Lordship, the issue is on.
Which page?
Lordship, the interim orders.
Third counsel to the petitioner.
Lordship, the issue is on, they're alleging that we have received royalty and IPR services from our Delhi unit. And they're alleging that we have not accounted these services. Therefore, they're taxing it on my behalf under section 35(6). Whereas we have actually not received these IPR services and the services have actually received by my LG unit in Noida. So this is the whole contention, Your Lordships.
But there's nothing forthcoming from the interim order.
That is, Lordship, it's on the exact same issue, Lordships. For the period 17-18 and 18-19.
Counsel to the petitioner submits that as regard the same SSC, the period?
The present period. Your Lordship, the one is for 17-18 and the other one is for 18-19.
17-18 and 18-19. raising identical contention as raised in the present writ petition. Interim order has been passed in WP 11508 of 24, 7730 of 2024. In light
Okay,
of the
present
same-
issue is for period 19 to 20.
In light of the same, subject to further consideration, there will be an interim order of stay of
Annexure A, your lordship.
Annexure A.
Yes, your lordship. Lordship, all three writ petitions may be kindly tagged.
Learned counsel. You appear for, Shaman Bank accepts notice for the respondents, list along with WP so and so. 11508 of 24 and 7730 of 24. IA 1 of 24 is allowed.
Obliged, your lordship. Let-
Continue. Now continue.
Serial number 43, Mahesh Arupal.
The petitioner, man. The petitioner is a PWD contractor. He doesn't come under the service tax. So I was
Last date, my lord, they have submitted that they have bills to
produced.
submit before the officer, my lords. During the adjudication, they haven't submitted the said bills, my lords.
Produce those bills.
My lords, if the bills may be produced before the
Yes, we'll,
adjudication officer, my lords, both the matters may be remitted back to the original authority.
Now, what is the contention?
My lords, their contention is that they are exempted from the said services. It comes under, they come under
Which
exemption
item?
list, my lords.
Which item?
25 or 12
PWD contractor.
notification. Notification ಕೊಟ್ಟಿದಾರಾ? But they said that.
Come, get ready and come.
Yes.
Next.
44.
Appearing for the petitioner, your lordships. This is the carryover matter from yesterday where the issue involved was whether this court had whether the maintainability of the petition was maintained on the ground that the officer or the respondent number 1 who issued the notices under 148A and 148 notice is located in Tamil Nadu.
Yes, Dilip.
My lords, I placed the Supreme Court judgment. My lords, he had to reply on that.
Yes, your lordships,
My lords,
Just read that once more.
It's para 7.
Yes.
Lord's internal page 5 may read. No, so far as the observation made by the High Court while concurring with the view of the learned tribunal that merely by filing return of income with new address, it shall be enough for the assessee to discharge its legal responsibility for observing proper procedural steps as per the Companies Act and Income Tax Act as concerned. We are of that. Merely mentioning of new address in the return of income without specifically intimating the assessing officer with respect to change of address and without getting the PAN database changed is not enough and sufficient. In absence of any specific intimation to the assessing officer with respect to change in address and change in name of the assessee, the assessing officer would be justified in sending the notice at the available address mentioned in the PAN database of the assessee. More particularly when the return has been required to be noted that the notice under section 143(2) of 1961 Act are issued on selection of cases generated under automated system of department, which picks up the address of the assessee from the database of PAN. Therefore, the change of address in the database of PAN is must. In case of change in the name of company or any change in the registered office or corporate office, the same as to be intimated to the registrar of companies in the prescribed format. And after completing the said requirement, the assessee is required to approach the department copy of the said document, and the assessee is also required to make an application for change of address in the departmental database of PAN. which is in the present case, thus he has failed to do so. My lords, in this case also, my lords, he was assessed in Tiruvallur, my lords. My lords, the assessing officer has issued 148 AB notice and 148 AD order also is passed. And subsequently, my lords, the case was transferred to Faceless. Assessment order also is passed. Even today, my lords, the jurisdiction of the PAN is, my lords, not in Bangalore, it is with the Chennai jurisdiction. My lords, they say it is only an ex-parte order. My lords, they can file the similar writ petition before the Madras High Court and get, my lords, this order set aside, because, my lords, their contention is the notices sent to them, my lords, was on a wrong email ID.
Yes.
Your Lordships, firstly, insofar as the decision of the Supreme Court is concerned, it stands on a different set of facts because that was a case where the assessee filed the return of income stating stating the new address, whereas as per the PAN database, which was not updated in that case, the notice under 143.2 was physically issued. So on that set of facts, the Supreme Court had taken the view that the address as per the PAN database has to be taken into consideration, and if there is no specific intimation as regards the physical service of notice. But in my case, physical service of notice was not attempted at all. It is only the email service which was attempted, which was sent to the wrong email address. And
No, in your PAN database that
PAN database, prior to the issuance of the notice, which I had demonstrated yesterday, I had changed my address to Bangalore. That is also one of the distinguishing factors here because in the case before the Supreme Court, PAN database was not changed. But in my case, that has been changed.
your PAN database has been changed,
PAN database is changed,
showing the address at Bangalore.
showing the address in Bangalore. Prior to the issuance of the notice, which I demonstrated yesterday with the latest PAN card and all. And that was also the case where the physical service of the notice was attempted, which failed, and therefore the issue arose whether there was a service of notice.
But now you get your instructions from your counterpart at Chennai.
Your Lordships, already 9 months have lapsed, and earlier also opportunity was given to them to.
Let us see, there may be some cross jurisdiction issue amongst them.
No, as far as the writ is concerned, the question is ultimately whether the part
Not that he has to just keep them informed.
Please.
Let him
At least if it can be remanded to the assessment stage where I can respond to 148 notice, and from there faceless proceedings be carried out. That should.
Where is it? Where?
No. Your Lordships?
Where?
No. So my only suggestion is this, Your Lordships. If it can be remanded back, and then I be permitted to also approach the assessing officer for the change in the jurisdiction, because.
That's why he's saying then you go in Chennai only and challenge it. So it will be remanded there.
But the site for cause of action, is not only in Chennai, it's also in Bangalore. That is my point. And I have judgments to say that where as a order is ultimately to be enforced, that is also the cause of action also arises there. Ultimately, for the purposes of writ petition, that is the ultimate test, not the status of the assessing officer.
Let us see, it requires some hearing wills.
At least an interim protection, Your Lordship.
My lords, I'll file objections. My lords, I'll get instructions. So
9 months
my
it
lords,
has been, Your Lordship, so at least an interim
There would
protection.
be an interim order of stay off.
Annexures D colli, G colli, and H colli, Your Lordships.
Annexure B, G, and H.
D for Delhi.
Annexure D,
G, and H.
D, G, and H only collectively, Pratisati, collectively. In the next date, the Council for the Revenue submits the statement of objections will be filed within 3 weeks. But on this point, it will not be decided for a long time. Anyhow, let's see. Yes.
Deeply obliged, Your Lordships.
45.
45, I appear for the petition.
You were not there in list number 2. List number 2, you were not present.
I apologize, Your Lord.
Yes,
Your
Last
Lordship,
time, Your Lordship, may recollect.
Your Lordship, it will be the same order as a batch matter.
correct, but we were finding out from each petitioner whether it's order in original or order in appeal for that review.
Order and original,
In
it
both.
also arises out of.
Both the matters.
Indeed.
Yes.
Both are ordered.
Yes.
Your Lordship, this is a case where the petitioner's input tax credit was blocked,
Yes.
negative
But
block.
we did collect, my lord. The joint
Lordship-
commissioner has instructed us that, my lord, is on 16th or 18th, my lordship, we will complete it. 16th or 18th, any day.
Your Lordship,
Did
the-
I
by
did the-
submission,
I
actually
did communicate, my
forwarded.
lord. So 16th or 18th, we'll make a statement. Meantime, they can file their returns beyond objection.
May I submit, Your Lordship?
No, no, just one. We are on the point whether they can file their returns.
Yes, they can, my lord.
May I?
And claim benefit.
If, my lord, if it is found to be eligible, the prospective part of it.
Yes.
In the meantime, let them file, let it come on 18th. Lord, we'll complete and make our
May I just
statement.
submit one memo, because on the last occasion, Your Lordship asked if practically I can file the returns on the portal. If I may just submit what happens on the portal, Your Lordship. This is the extract from his portal, Your Lordship. The current portal, Your Lordship, first page, the portal allows me only to file until March 2024. Beyond March 2024, the portal does not even allow me to file the returns. This is the screenshot. This is a portal as it exists. I've just printed before coming here, Your Lordship. The second page reflects when I go to file a returns, what is it that reflects on the portal? Now, for example, if Your Lordship will see the second page, for the financial year 23-24 for the tax period March 2024. When I click on it for filing, error message, Your Lordship. GSTR 1 IFF cannot be filed as GSTR 3B for February 2024 and GSTR 1 for February 2024 are not filed. Please try again after filing pending returns. So now I will not be in a position to file any returns even for going forward until and unless the earlier returns I will be able to permit. Now to permit me to file the earlier returns, whatever input tax credit that they have blocked, invariably I have to pay that for the simple reason that section 41, Your Lordship, of the CGST Act says, and Your Lordship, in this memo, the last page, if Your Lordship may see, it is a summons which the officer has issued. I had mentioned on the earlier occasion that now what will happen is they'll issue summons repeatedly. Although I have given all the documents, they will take statements from me, which will then be able, they will use it to produce it before this honorable court, and the proceedings will go in a completely different direction, Your Lordship. Now, this summons which has been issued to me, where I've been asked to appear on 12th, Your Lordship, the very same summons has been issued, which I have placed on record at page 66 in my writ petition, Your Lordship. In response to this, whatever details that was asked for, I have given all of it. Every single summons I have replied saying, these are the details which are in my possession, Please take note of it. If you're not agreeable to any of these documents, please tell me what are the reasons or what additional documents I'm supposed to furnish. And every time statements are taken from me, copies are not given. Arbitrarily video recordings are done, which is not given. Now, all that when I just see this summons, I don't even know what I should go and be prepared with. When what is in my possession, I've already given. And this is happening for almost 1 year, Your Lordship. Now, section 41 may be looked into, Your Lordship.
Let us see, then we'll decide it. There's no
Then-
point in giving any order for prospective is what you're saying.
Yes,
Does it
then in
sound-
the interim, I need to avail the input tax credit, Your Lordship. Because according to their statement, para 12 of the statement of objections, 22 lakhs input tax credit was available in my account. Now, I dispute that the input tax credit cannot even be blocked. But to just protect the interest of the revenue, if 10% of that amount I can deposit, Your Lordship, let them unblock the rest of the credit. 4 crore 67 lakhs, they say I've utilized it in the past and prospectively. Your Lordship, my business is seriously affected. I'm not able to do, I've taken a loan from my bank. Now I will be in a default if in the event I don't conduct the business. My account is going to be NPA. And what is beyond which is available, they have blocked. So any future business, if I do, everything gets appropriated to the input tax credit.
Yes, what do you say?
Lord, it can be had on 16th or, my lord, 18th, at 2:30, Your Lordship.
If you don't come back, I'm going to grant an hearing.
18th, Your Lordship.
And may I request that till
So
such time, respondents may not take any coercive precipitative action. Because for the summons also, your
Lord,
lordship,
so
let,
far as my lord, the 18th, your lordships are coming, they are producing the summons which your lordships have just seen in the memo. Lord, I had made a statement on the last date of hearing also. No officer is present till 15th. We are reiterating this.
on
Therefore-
12th, your
therefore-
lordship, kindly take
therefore-
note of the conduct. On
Oh,
12th, I'm asked to
Therefore,
appear.
therefore, my lord,
Just-
let it come on 18th, we will make a statement and be done with it.
No coercive steps to be taken till the next date. Relist the matter on 18th.
Obliged, your
My lord, so far as appearance, it may be kept up. In the meantime, if they want to furnish, let them furnish, let it put a quietus. That will help us only in arriving at a conclusion.
Your lordship, if the officer is not there till 15th,
That is
why am I
then why
called
precipitative
on
action?
12th, your lordship? Kindly take note of this conduct.
Yes, Lord.
Obliged.
46, Karthikeyan.
So far as
At
appearance. my lord,
2:30, maybe,
Let us see.
your lordship, at 2:30, if it may
18th,
be
let it
taken.
come, my lord, we'll make. Let it.
2:30, your lordship.
46,
Let it.
Karthikeyan.
List after 2 weeks at request.
47 urgent, 48, Manojayamma.
Lords, 48. Lords, I'll-
This relates to 16-17.
Lords,
Year
I'll have-
16-17.
Have to get
Okay.
instructions in this month. Lords.
Interim order is already granted.
Please.
And they
You
stay,
have
stay also been there.
Ah.
Let the stay
You have to
continue.
file your statement.
Please.
Statement of objection to be filed within 2 weeks. List after 2 weeks.
49,
Your lordship, I am appearing for the petitioner, your lordship.
Yes.
In this case, the petitioner had claimed ITC, your lordship, and which is GSTRB 3B has been filed belatedly. So
Just 1 minute, just 1 minute.
yes, your lordship.
It will opposite here.
AG.
You appear, is it?
I'll appear, my lord. I'll have to file my statement of objection to this.
Yes.
May have it after 2 weeks.
Your lordship,
There's already-
one
there's-
submission.
No, there's already interim order. There's already an interim
Yes, your
order.
lordship.
Let them
Yes, your
complete
lordship.
their pleadings.
Lord, it's a 16.
One submission, your lordship, the appeal before the Commissioner Appeals is pending, your lordship, still not been filed, past the order. There is a delay of filing the appeal. Due to that, they have not taken up the matter. So I'm just requesting that the matter can be sent back to the Commissioner Appeals, your lordship.
Lord, it's a
I have
16.
enclosed Annexure E, your lordship, the appeal filed details, your lordship.
No, but they want to file their objection, so we can't decide till they complete their pleadings.
And my lord, it's a 16-4 issue.
Let us
Yes, your
16-4
lordship.
issue. Awaited in the Supreme Court also. Don't see.
statement
weeks,
of
my lord.
objections to be filed.
Your
within
lordship, 2
2
weeks only, your lordship, can be
within 2
taken.
weeks. This is the meeting
Yes, sir.
thereafter.
Grateful.
Yes.
Till number
Much
50,
obliged.
50,
Interim order earlier granted is extended till the next day.
50, Sudhindra Bia.
Here for respondent.
Yes. Relist the matter
After 2 weeks, my lord.
after 2 weeks. Yes,
51,
I appeal for the petitioner, yesterday's matter, my lords,
yes.
with regard to 93-2, to credit
Yesterday's
the
matter, union was representing all three respondents, my lord. I had inquired with the department regarding that section 93, why
Yes.
that it is not reversed. My lord, now they have nominated me. They said, we'll instruct you accordingly because the union is representing 2 and 3. They have nominated me, my lord. I'll take instructions, my lord. A week after next, it may be called out.
Council Arvind Chavan accepts.
For 2 and 3.
they have filed their objections.
That is union has filed.
2 and 3.
Sir, the officer has filed.
Relist the matter.
Your income tax officer has filed.
24th,
24th,
My lord, 30th, my lord.
30th.
That's
Yes.
52, Ravi Raghavan.
My lords, appearing for the petitioner, the writ petition has been filed against an order in appeal, which has been issued by the JCCT appeal rejecting the refund of the unutilized input tax credit. The petitioner in this present case, my lords, they have exported services under Global Master Service Agreement and Shared Service Agreement to their parent company. And claimed refund of the credit, my lords. The department,
Take out notice, take out.
my lords, notice may be issued to center, my lords, Mr. G. We take it.
Third council,
Appeals.
additional commissioner of GST. And Council G1 accepts notice for the respondents.
My lords, a writ petition in the same, for the same petitioner for the previous period is already pending. This
List
may be
along-
tagged with it.
List along with WP number,
282900 of 2023, my lords.
write it and give it.
Yes.
Office objections to be complied with in the interregnum.
53. Ramutya, 53.
It's a petition against the 148 AB and AD and subsequent order. I'm challenging the notice issued under 151A, my lords. They have not followed the procedure. And sanction is obtained after 3 years from PCIT instead of PCCIT, my lord.
Income tax. Income tax.
Lords, I'll take.
Petitioner is a pensioner, my lords. He had made deposits in the earlier year, which got renewed. That's been brought to tax.
You look into it. then.
I'm challenging the notice also, my lords, 151A. It's not notification, faceless and
Lords, they have not filed reply to 148 AB, my lords.
They have not filed reply.
They have not filed reply to 148 AB. Lords, at page 17. Page 17.
Yes.
Lords, para 5, the ASSI was required to furnish reply on or before 30th March 2022. In response to the notice, the ASSI has not filed any reply either.
Why you have not participated in the proceeding?
my lords, he was not an SSA. All the notices were uploaded. He's a pensioner, my lords. And he was not aware of the notices uploaded in the portal. And in the course of the assessment, he participated after filing a return and
No, he was not a previous SSC.
he was not a previous SSA.
Notices were sent to which address?
By portal, my lords, on the PAN database.
Then we'll send it to the
Stage of 148 AB, my lords.
and reply to 148 AB. The petitioner has sought for setting aside of the order under 148 capital A small d at annexure B. There's also the notice under section 148 and the order under 147 read with section 144. Read with section 144 capital B at annexure E. In the case of the petitioner, that the petitioner is a pensioner and was not an SSC previously, and notices of the proceedings were sent to the portal on the basis of the PAN details.
Yes,
which the petitioner had no occasion to verify. Full stop. He submitted that all proceedings have proceeded without any stand of the petitioner, and the petitioner is in a position to demonstrate that no order under 148 capital A small d would have been passed, as the amounts referred to were mere renewal of earlier deposits.
Yes, madam.
Full stop. Taking note of the admitted position that all proceedings have proceeded without participation of the petitioner, and also noticing the contention of the petitioner, the ends of justice by relegating the matter back to the stage of 148, to the stage of reply to the 148 capital A small b. Accordingly, the orders at
Annexure B, my lords, 148 A, AD.
B, C, and E.
And E, my lord.
Where is D now?
D is copy of the return, my lord.
B, C, and E are set aside. Matters relegated to the stage mentioned above or kept open.
Lordships may kindly consider to issue notice to Shushal, reputation one
There's
seven
nothing
Shushal.
shall accepts notice for the respondent. Yes. Apurva now.
Four o'clock matters. Further hearing cell number 105. Vijayant Babu, 105. Hello.
Lords, may I make one submission?
18.
Item number 94, my lord. Come up in preliminary hearing, my lord. The matter has to be remanded back.
Let us see. Just wait.
May I request on Tuesday, my lords, in fresh matters,
Dates will be given.
94, my lords, in the fresh matters list.
Dates will be given. Just wait.
Please.
Yes. Yes.
Real number 63. Adjournment may be given. Or
No,
just one
no.
minute.
No, dates will be given by the court officer.
105.
Serial number 57, my lord, it may be taken up on Tuesday.
Dates will be given by the court officer.
Obliged, my lord.
105.
Item number
Vijay,
75 is a case of GST on corporate guarantee. My
Yes.
lords have issued interim orders in a similar matter in the same petitioner's case. This is only a subsequent financial year.
Serial number
75.
75, same in.
Same order, same petitioner. This is for the financial year
In light of the
18-19. The
contention.
petition is for 19-20.
In light of the contention that in the case of the same SSC for a different period.
25.
In an identical factual matrix, this court had passed an interim order in WP 15927 of 2024, which reads as hereunder. Accordingly, in the present matter as well, there would be an interim order on same grounds. The interim order reads as follows. Accordingly, there would be stay of
Annexure B, man.
annexure B. Who appears in that matter?
My lord, I appear for 1 and 3. My lord, 2, 4, 5, my lord, Samant appears.
Given for 1 and 3, Samant Naik for respondents, 2, 4 and 5.
Well, the office objection has been raised on the ground of the annexure A being a digital copy. I filed an affidavit to that effect. That may be dispensed with.
Is kept in abeyance.
Much obliged.
My lords, in 94, my lords, there is no interim order. My lords. 82, I need interim protection, my lords.
Let us see, just wait.
My lords, 94.
Yes.
My lords, there is no interim protection, my lords. They are proceeding with the recovery.
No, I'll see. Let us see.
Tuesday, my lords, in fresh matters list.
Dates you can take from the court office.
Serial number,
105.
serial number 60, my lord, that next week, now 16th.
Dates will be given by the court officer.
My lord, 104 lordships had kept at 2:30.
Let us see this.
May I wait? Yeah, my lord, I'll wait, please.
I don't know if I'll be able to accommodate, but let me see.
Right.
You could have come through online, madam.
My lord, there are some documents to be presented.
Let us see.
Right, I'll wait.
105.
My lord, if they are producing, my lord, additional documents afresh. Them sort of copy on me and my lord, advance. So I will take.
Are there any fresh?
There are documents your my lord friend is relying upon.
My lord, may I take 1 minute of my lord's? Last time I was only on refund. Now my friend went on bill trading and all those issues. The show cause notice is issued, I have given 500 pages compilation also. All the details are with them. Yesterday also I was told, he says, don't give me the box file, give me the details. I've given everything. Now the issue is, he is insisting on bill trading and all those things. I just want to point out, my lord, there are eBay bills, there are fast tag, there is proof of delivery, everything. Now, it's still if he is objecting on that, because I'm only on refund under Article 265, nothing more.
All disputed questions of facts.
No,
They have
correct,
made
eh?
reckless
There are
assault
no
against the
disputes.
officers.
No, correct.
Show cause notice has been issued. Adjudication is pending before the my lord adjudicating authority as of now.
Correct, but
Yes.
you'll have to look into the judgment that I passed.
Yes, yes, bundle
My lord,
technology.
yes.
Well,
We are
circumstances
only-
are a little different from the, what was there
Same
in the except
circumstances, let me point out.
circumstances.
That's what, I will wait, my lord, I'll wait.
No, now the contention will be one of self-ascertainment.
Yes.
But that I've that I've seen in that, I've considered that, and division bench also has upheld it.
Yes, it has confirmed by the division bench.
So unless adjudication is done.
Adjudication is going on, my lord.
Correct,
Depends on.
but until it's completed, you can't.
I'll just see, my lord. I'll just see if they are producing any additional documents, my lord. I was
No,
just.
no, I just want to show to my lords, not production. That is all given to show cause notice. Don't worry about that.
So until the case is until the adjudication is complete.
Please.
That cannot construe it to be self-ascertainment.
Precisely.
And if
My
that
lords
is,
are right.
if that is so.
No, my lord, self-assessment comes, my lord, before adjudication.
Self-ascertainment.
Self-ascertainment
Cannot
comes
be-
before adjudication.
Correct, but that cannot be the department, even in that case, took up the ground that it will amount to self-ascertainment, which we have rejected specifically,
Precisely. My
stating that you can't do that. And then I have, in fact, the single, this court merely said, consider refund. Division bench said, no, you order it.
Precisely.
Anyway, my lord, now the, my lord, adjudications are going, adjudication proceedings
but
are on.
The same.
Now, my lord, if the adjudication, my lord, if he drops it, my lord, entire thing, they are entitled
No,
for.
but that is the same ground. No, that's the same ground we have considered.
Precisely. My lords.
That's the same ground we have considered.
My lords are
Stating
perfectly right.
that you cannot hold till adjudication. You'll have a look at it carefully.
Please.
And the division bench has upheld it with further direction of automatic refund because of Article 265.
65.
So though this court said, no, you consider refund. And but they said no. So you have a look at it.
Please.
They have rejected the contention of
Please.
self-ascertainment.
Please.
So we'll have it on Tuesday at 2:30.
Obliged, my lords. I'll be
At 2:30.
obliged.
Have a look at it.
Please.
You come through VC, madam. You come through video conference. Reason being, we also feel uncomfortable turning away outside counsel. I'm saying it should not matter, but somehow little discomfort in turning away people without hearing the matter.
Not fine. I appear for the petitioners.
Where did we stop last time? Last time in this matter?
So last hearing, the respondent counsel submitted. It is admitted that there was exemption prior to this period and there is exemption after this period.
Period exemption is
WP number 6979.
Ah.
I was to make few submissions
7-9, you will also make any take.
taken.
6-9?
7-9-24.
That is the latest one.
Manjunath. 6979. 6979.
My lord, annexure. Annexure G, you will also make it. Page number 57.
Just 1 minute.
This your lordships have already perused, my lord, on the last date of hearings. I brought it to my lord's notice that on page number 58, item number, my lord, Roman 8, your lordships. I don't want to repeat it because my learned friend said that we have admitted that it is
Not the case.
not so. That's what I'm. My lord, this is the, if in entry number 25 for item number A, the following item shall be substituted, namely,
Not even amendment, it's substitution.
it is by way of a substitution. My lord, the scope of that exemption clause has been restricted to a minimum, to the specific and core service. As your lordships have examined on the last date of hearing, the contracts and work orders executed by the BBMP is for supply of manpower and, my lord, the vehicles and nothing else. Now, the BBMP has to, my lord, say that whether they are carrying out the, my lord, the core activity of solid waste management, or, my lord, it has been outsourced to some other agency. No, ನಂದೆಲ್ಲ ಮುಗ್ದೋಗಿದೆ.
I am going to.
No, but even otherwise, it's your case.
Yes.
That what has been given to them by way of work orders or tenders is the spectrum of supply of manpower
Yes.
and vehicles.
Yes.
So, according to you, since in light of the words in relation to
Has been
having been
omitted.
deleted, what would come is only if you are doing water
Specific, my
supply,
lord.
public health,
Yeah.
solid waste management. So only if it is solid waste management by itself,
Right.
it is.
Covered.
And since this is in the nature of the, this is the chargeable. Charging.
My lord, this otherwise chargeable.
So this is the exemption, is it?
My lord,
Yeah,
this
yes,
is an exemption notification.
So it has to be strictly construed.
Section 66, 65B clause 44. my lords.
It has to be strictly construed.
Yes.
That's my case, my lord. Precisely, my lord, that's 60 by B, my lord, 44. Service means any activity carried out by a person for another for consideration and includes a declared service, but shall not include so and so.
This comes within that shall not include.
Any activity carried for consideration.
So once it goes outside the exemption, automatically it comes under
It becomes taxable.
65B.
Yes, 44.
40.
And it doesn't fall under the negative list. That is another point. If it had been in the negative list, there was no need to issue an exemption notification. Exemption comes, otherwise it is taxable. This is
Yes.
my learned friend wants
Just
to.
I want to have only 10 minutes. In 697, I appear for respond number 1. The order which has been passed, some portion of it was perused on that day for the sake of convenience. Now I request you also to turn to page number 112 in the very same writ petition, 6979 minutes, 112 minutes. 112. May I read minutes? The noticee in his reply dated 9/12/2019 and 7/9/20 as submitted that they had provided a collection and paragraph 16 minutes.
14, huh?
Page number 112.
Yes.
Paragraph 16 minutes.
Yes.
The noticee in his reply dated 9/12/2019 and 7/9/20 has submitted that they had provided collection and transportation of garbage, toilets and urinals service to BBMP by way of contract labor and has claimed that their services are exempted with a mega exemption notification number 24/2012 and 20th June 2012 with a entry number 25A. That is services provided to government, local authority or a government authority by way of water supply, public health, sanitation, conservancy, solid waste management or slum improvement and upgradation. As they have provided their services, namely solid waste management, to BBMP, a government agency, therefore their services may be treated as exempt services and thus no service tax will not attract to their receipts. Now, this is their crux of the matter, what they contended before that. Actually, the contracts very clearly disclosed that they did not do anything except transport service, supplying the manpower and also machinery. This kind of transportation. Now, the analysis has been done clearly. Now I will discuss the taxability exemption to the noticee, service income and exemption available under the mega exemption notification 2012 dated 20th June 12. The legal position on taxability of services provided to local authorities as under. Both the periods have been culled out, my lords. Position from 1/7/2012 to 10th July 2014, that is serial number 25A of notification number 24/2012, ST dated 20th ordinarily entrusted to a municipality in relation to water supply, public health, sanitation, conservancy, solid waste management or slum improvement and upgradation. Position from 11/7/2014, this is important, my lords, to 30th June 2017, serial number 25A of notification number 25/2012 dated 20th June 12 as amended by notification number 6/2014, just now my learned friend read, my lords, 14, dated 11/7/14, services provided to government, local authority or a government authority by way of water supply, public health, sanitation, conservancy, solid waste management, or some improvement and upgradation or repair or maintenance of so and so, it is given. We are concerned about to entry B only, manners. In that specifically, if we look at juxtapose both entries of 2012 and notification and the 2014 notification, manners, what is conspicuously missing is that carrying out any activity in relation to any function ordinarily enters to a municipality. To up to that extent, my lords, in relation to, it has been omitted. Now, going by this the notification itself presupposes that exemption means services taxable for a particular period, government can exempt from payment of tax. That's the only thing. The moment it is out of the bracket of exemption, automatically they go back to the serviceable, taxable services only. There is no ambiguity on that point. Here, two things have to be looked into. First thing is that they are into what? According to their contract, they are supplying the manpower and the vehicles for the services to be utilized by the BBMP. BBMP has not the delegated the entire process of solid waste management to them. It is not the case. Solid waste management starts elsewhere and it is done by the very municipality itself. Only they have service availing certain services. That notification according to 12 and 14 onwards, it has been stopped. The adjudication is only for that period only, 2014 onwards. Now I request you lordship to turn to page number, same continuation, page number 19. 19 minutes. 113, sorry, paragraph number 19. And may I read, manners? The common features of the work supply orders are that the noticee, that is the contractor, shall supply certain number of porokarmikas and machinery and equipment related to collection and disposal of garbage, dry and wet, at the specified wards of the BBMP. The BBMP used its workers and equipment like auto tippers and compactors, etc. for solid waste management work. The workers collected and carry garbage and waste from the households, streets and take it to secondary collection points, that is treatment plant through compactors, where BBMP has to dispose the said garbage MSW. Thus, the contractor has to supply only the number of poro companies, drivers, helpers, supervisors allotted as per the supply order, and based on the number of manpower supplied, payments is made to him. Next, 21 is important minutes.
20 is also
21.
important.
Just
Para
1
20
minute.
is also
Just 1
important.
minute. Jeevan, now suppose, I'm just thinking, suppose we were to reject the writ petition, then their appeal also goes or how?
No, appeal won't.
Not the right of appeal?
Right of appeal still remains.
Limitation in the court.
Only thing is, limitation, because he was pursuing this remedy before this. 14.
Section 14 may have to be made applicable expressly by the.
No, but then we must not voice any opinion.
That's keeping open all contentions open, it may be relegated to the respective.
we were to-
That will act, will be detrimental to his interest, because adjudicating authority as well as appellate authority will be swayed by the
Observations.
Certain. Any merit. So this is the list lordships can say, and leaving that open, depending on the documents which have been produced before the authority, they may take independent decision. Otherwise, my lord, it will affect his, right of appeal will become futile. Any observation on that is.
Otherwise, we must say on the position of law
Otherwise, my lord, if you lordship say.
and then close it here only, that's all. There are only two options. One is either permit them
If
to.
my lords are allowing it, the rate petition, there will be no problem. But if lordships are rejecting it, my lord, then it will take away his right of appeal. My lord say.
Correct, but if the interpretation is called for.
Yes, what has to be done?
On a legal question.
No, my lord, legal question, lordships can, my lord, interpret it. But subject to what documents he produces before the authorities.
But they've already produced some of the work orders here.
So, my lord. Now, if they are going to prefer an appeal, my lord can say that, my lord, they have a right of appeal. My lord, convince the, my lord, appellate authority on, with reference to the documents or documentary evidence, my lord.
Let us see.
Nature of duty performed them that may be established before the respective authorities. Since there is an alternative efficacious remedy available, they may be relegated with the.
So correct, but I'm saying now what remains is only looking at the
Interpretation of law, man.
work order.
Yes, work orders.
Or
Only work orders.
and interpret whether it comes here or out.
My lord, if that is done, my lord, by this honorable court,
Then there is.
then we put an end to the, my lord, even appeal also will not so move. But since he has chosen to, my lord, this thing, my lord, then he has to.
That may be the only consequence.
Only consequence.
In the event.
Yes, in the event, my lord,
We are going to reject it.
Paragraph 21 minutes.
Para 20?
21 minutes,
Yes.
bottom. It is also, lordship got it. It is also seen that as per the income returns and 26 years of the notice, that the BBMP has deducted TDS under section 194C of the Income Tax Act. Section 194C of IT Act reads as follows. Payment to contractors under section 194C. Any person responsible for paying any sum to any resident here and after in this section referred to as the contractor for carrying out any work, including supply of labor for carrying out any work in pursuance of a contract between the contractor and a specified person shall, at the time of credit of such sum to the account of the contractor or at the time of payment thereof in cash or by issue of a check or draft or by any other mode, wherever is earlier, deduct an amount equal to so and so. Now that payment has also under section 94C of the Income Tax Act, they have deducted as manpower services. 194C. Contractual payment. Now coming to paragraph number 22. Minutes. It is seen that the Ministry of Environment and Forest with a notification dated 25th September 2000 so and so has notified rules to regulate the management and handling of the municipal solid waste with the manual Municipal Solid Waste Management and Handling Rules 2000, which apply to every municipal authority responsible for collection, segregation, storage, transportation, processing, and disposal of municipal solid waste. As per Rule 314 SW Rules 2000, municipal authority means municipal corporation, municipality, Nagarapalika, Nagara Nigam, Nagar Panchayat, municipal council, including notified area committee or any other local body constituted under the relevant status and statutes, and where the management and handling of municipal solid waste is entrusted to such agency. Further, as per Rule 4 of SW Rules, the responsibility of municipal authority are as below. That has been extracted minutes. Paragraph number responsibility of municipal authority. Every municipal authority shall, within the territorial area of the municipality, be responsible for the implementation of the provisions of these rules and for any infrastructure development for collection, storage, segregation, transportation, processing, and disposal of municipal solid waste. The municipal authority or an operator of a facility shall make an application in form number 1 for grant of authorization for setting up waste processing and disposal facility, including landfills, from the state board or the committee in order to comply with the implementation program laid down in Schedule 1. The municipal authority shall comply with these rules as per the implementation schedule laid down in Schedule 1. It is therefore clear that municipal authority, which in the present case is BBMP, is responsible for solid waste management. Therefore, it clearly implies that the noticee contractor is only supplying the manpower and the actual SW work is done by the BBMP. The activity of providing manpower supply service is not an exempted service as per the notification number 25/2012 so dated 20th June 2012 and amended notification number 06 of 2014 ST dated 11/4/17, even though services are provided to a local authority. Therefore, this is how the order has been culminated. Malars, the contract documents have been already read in Malars. I don't want to repeat the same Malars. And as far as the position is concerned, as already repeated Malars, it's not in the negative list. It's only exemption. All of the things are completely in the notification covered. What was actually what was not covered. Accordingly, this order has been passed. In that view, the writ petition request to be rejected.
Yes. Can I make few submissions, my lord, on behalf of BHB? Lord, I represent, Lord, the authority, municipal authority, my lord, in two matters, 6345 and 1550. 6345 and 5150. 5150 of 2020. 6345 of 22.
50.
23.
No, but now it's a matter between them and the department. What do you?
I concede. Lord, what I say, what I want to make a submission here is, ultimately, my lord, if an order is passed, or if the petitioners are directed to pay the amount, because this is an order passed as against the petitioner is concerned. If such of an order is confirmed by this court, saying that this order is right, he has to bear primary liabilities on him. And he will come against me again. Ultimately, I am responsible. I'll have to bear that amount. So this order to some extent affects me also, though it is not addressed to me. So that is why, my lord, petitioner, my lord, has
not challenged it.
Since it is not addressed to me, I cannot challenge it. I only try to make the submission, my lord, that I want to support the petitioners, whoever has approached this court, insofar as how this exemption and the taxation rules have to be interpreted. To that extent, I am not saying for a minute, my lord, totally there is a liability on me now immediately and things like that. I only say that ultimately, my lord, I have to be saddled with these amounts. Otherwise, he pays the amount, and then if I don't pay it, he'll approach this honorable court seeking for a direction against me, and it comes to me. And what is the object of granting this exemption? I think from this angle. Purpose of granting this exemption, insofar as solid waste management is concerned, my lord, I say that I should not be saddled with this amount. I only think from this angle, that's all. If this exemption were not to be granted, definitely I am liable to pay the amount to the contractor, or contractor in turn has to pay to the department. This exemption, which makes it very clear that insofar as services provided pertaining to solid waste management, the wordings used is very important. Solid waste management stands exempted. Makes it very clear that any management pertaining to solid waste is exempted. Earlier, your lordship may kindly appreciate, earlier, the exemption that was granted in the year 2012, that is by virtue of this mega exemption scheme or things like that. Earlier, it had a very restricted meaning. I think it from this angle. It had a very restricted meaning. What is meant by solid waste management? Related to services, or carrying out of any activity in relation to any function ordinarily entrusted to municipality. It had a restricted meaning. Now, by virtue of further substitution in the year 2014, these wordings have been removed. So, wide meaning has been given to solid waste management. Any person who gives his services to, in any manner, any form, to a municipality or to a local body or to government, and that service which he provides, he or she or it or whatever it is, provides, pertains to solid waste, then that should be exempted.
Amendment Act, do you have the objects of the Amendment Act?
This Amendment Act object, they only have to give it. I don't have anything. My lord, that is where I said, kindly see, may I request your lordships to kindly turn to Nimsha, sir.
The
Number
objectives
42.
of the amendment is found in Annexure C of the first petition. It is there in all the
ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಇಲ್ಲಿ ಅದಕ್ಕೋಸ್ಕರ ಕೇಳ.
Page number 42 minutes.
Page number
42
of what?
of my annexure of
ಯಾವ petition, sir?
6979.
ಆ ಫೈಲ್ ನನ್ನ ಹತ್ರ ಇಲ್ಲ ಅದು.
6979.
ಸರ್.
ನಿಮ್ಮ ಫೈಲಲ್ಲೂ ಇದೆ.
Lord, I only read it like this. Kindly, my lord, prior to taking your lordships through the objectives of it, may I request your lordships, plain reading. Let us not give any
Page number 44.
interpretation to this. Plain reading of these two sections prior to amendment and post amendment.
1 second.
Annexure.
Page number 44.2.2.1 deals with that, man. Why it is being 2.2.1. So just for clarification, you may continue, minutes.
Yeah.
Continue. 2.2. Page number 44, 697. Exemption being withdrawn, notification 25/12 ST.
Right. Now kindly, may I request your lordships to turn to Annexure H, page 101 in 6345. 6345 of 2022. This is the show cause notice. These two sections, post amendment and pre amendment, are extracted here. Page 101, Annexure H. Show cause notice ಅಲ್ಲಿ extract ಮಾಡಿದಾರೆ. ಆ section ಮಾತ್ರ ಓದ್ತೀನಿ ನಾನು. When I read this particular section, what is the first impression what I am going to get?
Yes.
ಅಥವಾ ಯಾವ್ದಾರ, may I read that, my lord? Para 2, intelligence. Shri so-and-so Bangalore is a BBMP contractor and engaged in providing manpower supply to BBMP, a local authority, for carrying out cleaning work and other work entrusted by BBMP and also the other private entities. They are registered with service tax and have not paid the service tax on the consideration received by them from BBMP and from other under reverse charge mechanism. In terms of notification number 25/22/2012, ST dated so-and-so, services provided to local authority by way of carrying out any activity in relation to any function ordinarily entrusted to a municipality in relation to solid waste management was exempted with effect from 1/7/2012 onwards. However, the said notification was amended wide notification number 6 of 2014, ST dated 11/7/2014, wherein services 25, services provided to government, a local authority or a governmental authority by way of A, carrying out any activity in relation to any function ordinarily entrusted to a municipality in relation to a water supply, public health, sanitation, conservancy, solid waste management, or slum improvement and upgradation, or was replaced with, this is very important, 25, services provided to government, a local authority or a governmental authority by way of A, water supply, public health, sanitary conservancy, solid waste management or slum improvement and upgradation. Kindly see the plain reading of it. Earlier, what was included or what was exempted is only services in that regard. Now, by removing the words carrying out any activity in relation to any function ordinarily entrusted to municipality, my lord, these entire wordings have been removed. So, thereby, any activity pertaining to solid waste management, if an assistance is given by any person,
Jeevan is wondering. on the
Canon of
interpretation
taxation law.
going antithesis to tax jurisprudence.
That's not what.
No, that's okay. That's his interpretation.
that is my interpretation, my lord. I only find like this because earlier, my lord, I concede whatever, my lord, with due respects to the judgments placed before your lordships, that exemption notifications have to be strictly interpreted. And then insofar as taxes are concerned, it can be liberally interpreted and things like that. I can understand that. But what I say is ultimate object is to save this entire aspect of solid waste management from taxes. Ultimate object. Otherwise, there was no necessity for granting exemption at all. The wordings now, my lord, is very useful or very important to say solid waste management. What is that solid waste management? My lord, if I do the work on my own, I can say this. If I do the work on my own, there is no question of service tax. Now, if I am trying to manage or if I am managing collection of this particular solid waste from right from day one up to the last stage, this is called management. I am managing this solid waste. Towards this management, I can always say that I can hire the services of certain persons by calling tenders and then get the entire thing collected and disposed of. Right from point number 1, that is collection, till the date of disposal, till the time of disposal. Entire thing is called management. So, my respectful submission to your lordships is, if at all I were to be saddled with this cost of liability, this cost of service tax, ultimately, my lord, what is the purpose of this particular exemption at all being given? Otherwise, legislature, my lord, would have made it very clear, like how it had given a restricted meaning there at point number A, prior to amendment. My lord, it would have continued like that only.
Let's see, we'll continue.
Please.
Mr. Babu, one point you just keep in mind as a matter of legal strategy. If the court were to agree with you, then you come out clean. But if we were to agree with the department, then you'll be losing your right of appeal.
Appeal also.
Because then we'll have to determine in these proceedings the contention, whether it comes within the tax bracket or outside.
Well, my submission would be it comes well within the jurisdiction.
That I'll
this
hear.
court,
That I'll
because
hear.
the very issue of notice is without jurisdiction.
That I'll hear you.
The writ jurisdiction of this court under 226
No, I
cannot
think-
be taken away by.
No, not that way. If I were to rule against you in the writ, then you will not have.
The right of appeal will go away. I concede that.
Well,
Yes.
so just to put some clarity to this.
No, let us,
my-
next I'll have to rise. We'll continue.
Please.
Go next. Next. Eighteenth. 18th. How much time you'll require? Roughly how much time?
About an hour's time.
Yeah.
Serial number 63, my lord.
Yes.
So for the seizure of goods, my lord. I kindly have tomorrow, my lord. It is the last date, my lordship has ordered to do the password of the seized laptop
I note.
of one of the directors, my lords.
Serial, can I mention, serial 95, we have the benefit of an interim order in a connected matter, which we need in the connected matter as well. There was a demand notice raised yesterday. Similar terms, we need an interim order. So far as interest is concerned, we'll undertake to pay the principal on the GST.
Same as yesterday.
Same as yesterday, but a different party, different club.
Who appears? Who appears for the revenue?
Deshpande. I have it tomorrow. No, we take it.
Knowledge.
Mutuality.
My lord, serial
Please.
number 81, my lord. It's a covered matter. A date may be fixed. my lord.
Yes, yes.
Which one's that? 81.
ಇಲ್ಲ ಅದು ಸರ್ ಅದು ಸೇಮ್ ಹೆಡಿಂಗ್ ಅಲ್ಲಿ ಬರ್ಲಿ ಸೇಮ್ ಅದು ಕಂಟಿನ್ಯೂ ಆಗಲಿ ಅಂತ
ಆಫೀಸಲ್ಲಿ ಜೋಡಿಸ್ಕೊಂಡು ಕಟ್ಬಿಡಿ ಒಂದಕ್ಕೆ ಹಾಕಿ.